Today, let me start with a mention. You see, today, if I can't upload the orders at by 4:30, the orders would not be available unless till the next working day. Yes.
But in this sector, item number 22, my lord.
Yes.
We are for opposite party number 2 and 3.
Yes.
But we have to file my lord opposite short in this line. Yes, my lord.
22.
So, 22, my lord.
22.
Yes, 22. So let it be posted after my lord.
Yes, that is.
This is from which place?
Kokrajhar district. Let it be posted after vacation.
CDB retail note.
Should you can send back and keep a scan copy and or the photocopy and send back. No point holding the investigation. Both sides are duly represented. On the prayer made by Mr. M. U. Mandal, counsel for respondent numbers 2 and 3. Time is granted to file objection. Next paragraph. Ms. A. Begum, learned APP, has submitted that the case diary is available. First of the learned APP is permitted to retain a photocopy of the relevant pages of the case diary and send back the case diary for further investigation. For investigation, not updated for investigation. List on, give a date after vacation.
Lordship, 10, 11, 10, 11. Lordship.
10, 11, okay.
Leave lawless.
Item number 24, your lordship.
24,
24, your lordship.
Yes.
I had an iron this case, but this is not yet the record. So let's come.
call it. Item
33 of the second.
33,
Yes, lordship.
yes.
This case, some type of an error in the FIR. So I don't think allowed to connect this by hand.
Okay,
Leave the
33, correction allowed. Yes,
My lord, I think to mention item number 13. my lord. Kindly
1,
pass
3,
on 1, 3. Kindly pass on the note.
okay. Parcel for the day is paid for by learned counsel for the petitioner. You have the case diary?
Lordship, LCR is received. Lordship.
Oh, LCR is, okay.
My lord, another matter, that is item number 21, my lord.
Yes,
Kindly
This
pass on
also?
this matter also.
okay. Here, you have the case diary?
Lordship, we have not received that. 20. Oh, we have received. Lordship. We have
Here,
received.
you see, send back the case diary and
What is the photo?
give a photocopy. Both sides are present. On the prayer made by learned counsel for the petitioner, list after vacation. Post topic. Ms. A. Begum, learned APP, has submitted that the case diary is available. The same order, she is permitted to retain photocopy and send photocopy of the relevant pages and send back the case diary for investigation. Okay,
Obliged, my lord.
Make resolution. Lordship, you have to mention item number 23, Lordship. CD is not available. Lordship.
CD is not available. Lordship. We have not received. the CD.
okay. List after the ensuing revision. Give a date, this one so and so, by which time the
10, 11. Lordship.
Ms. A. Begum, learned APP, shall produce the case diary.
10, 11.
My lord, in item number 21, interim is there.
21 interim is there.
Yes.
Okay. Interim extended.
Obliged.
I think maybe 21 then give it a BA or AV case.
I have not did the-
Did.
not did the- In bail matters, we are giving fixed dates.
Lordship.
Delivery of order, item 31.
Yesterday, there was a mistake on my part. Due to our mistake, the file did not go back home for my study. This application is dismissed. Parties are directed to appear before the trial court without waiting for a notice. Uh, on 6/11. Just check this. I did not have even time to go through it. Please check it, both of you. If I've missed your submissions. Yesterday, I went from here at 7:30. So by the time everything was over, I did not have time to again go through the order. So please check it. I may have done some error. I may have left out some of your submissions.
Motion BA, daily list item 1.
First few paragraphs you can omit. It is only that operative part where I have referred to your submissions. It's only 2 paragraphs.
Yeah, please.
Yes.
Case of child marriage act, your lordship. Child marriage act. Someone was arrested.
Child marriage. What is the age of the girl?
Age is 70.
17. Married when?
Actually, here, the problem is different, your lordship.
Yes.
His brother married another girl. So police came to India on the basis of the FIR and arrested him, and he found this lady, this minor girl in the house, and just without having any inquiry that the petitioner was arrested. He is the brother of earlier.
Okay, but what is the date of marriage?
Date of marriage is not there because till they have not got married.
Also, information may be in some lordship. There is a rule, order lordship, that 6 and 7 POXO is their lordship. So my ladder friend must have to send a notice lordship and.
In this case, your lordship, last is some. Your lordship has passed the order.
Lordship.
If your lordship goes through the order, this will give your lordship will pass the order. In such cases, granting a bail. But in this case, is some exceptional, your lordship. There is no marriage to this yet. And it may be behind the bar from 3 October, part of October,
10.
16 January.
There is a division bench order lordship that now.
Division bench order.
Lordship, I will
No,
provide.
it's okay. When you say it, I'll accept it. Okay. Then I'll have to issue notice if there is a division bench order.
It is the order in the last day. Another 4 days passed.
No, but if there is a division bench order, it is brought to the notice. I can't, I'm not an appellate court to the division bench order. Because they have experience in dealing with it, they will know more than at least me in the division bench orders on POXO matters. Mr. Anand, heard Mr. Anand Upadhyay, counsel for the petitioner, and Ms. A. Begum, learned VP for the state. The learned APP has submitted that although this court had granted bail previously in such matters, but there is a division bench order of this court requiring notice to be sent to the informant in cases involving offences under this POXO Act. Accordingly, let the case diary be produced from so the petitioner shall take steps for service of notice on the respondents. Number 2, by registered post with AD as well as by Dasti.
By the citizen.
No, registered post will have to take.
Pro police station.
Huh?
Pro police.
No. Dasti you can serve it. If you have relationship with number 2, they will accept your service. and
I filed affidavit.
and file an affidavit of service. So with the case diary, we also, case diary along with the medical examination report of the victim, we also produced. List on, reopening is on
Six.
sixth,
It is
on
seven,
six,
you're also at seven.
7, okay, 7/11/2023.
Public.
Item 2.
Here also POXO. No, once you have said, heard in the last order, the same order. But here it will not be Dasti, only registered post. Heard Miss T. Rajkua, Council of the Federation, same order. 7/11. Issue notice. Just in that notice, you say the notice shall be processed by the registry. It is given to you.
It will come to me in the office, Lordship, then
Huh.
I'll send.
That it would be processed by the registry and thereafter handed over to the learned APP for being transmitted to the respondent number 2 through the jurisdictional police station.
Got
In both the cases, huh? Same thing. Yes. No, maybe, but POXO is there. POXO is there, we can't grant you bail. Unless notice is served. Because that is the mandate of the division bench.
Item 3.
NDPS. 20B and B2C. Will issue notice, you produce your file your objection or produce the case diary.
And then Lordship, in this case, charge was framed on 6/5/2023.
6.
6/5/23. First, Lordship, first PW2, PWs were examined. First was on 6/5/23, second was on 3/10/23.
Total number would be
Next date is fixed on 30th of August.
30th of August. August is gone.
No, sorry, October.
October. Okay, just give the status and your objection. Mr. S.K. Das, counsel for the petitioner, and Mr. S.C. Kalan is standing also for the NCV. Issue notice on the respondent. So objection, if any, be filed by 6/11/2023. We said did the learned standing counsel for the respondent shall inform the court about the status of trial. List on 7/11/2023.
It's here, maybe for
Pardon me,
it's here, maybe for NCR.
it will not be required. It will not be required. Is it required?
Not be good. This is still will be.
You,
Lordship, scan copy of order sheet. Scan copy of order sheet of it.
no, in your status, you will already give,
I.
so we don't burden the court. Next para, before the distance, so right. As the trial has already begun, instead of calling for the scanned copy of the LCR, we permit the respondents to we deem it appropriate that instead of calling for the records, the objection by the respondent will suffice. So therefore, the therefore, subject to further orders that may pass, this the requirement of LCR is dispensed with.
Item 4.
Also, NDPS different, transit NDPS.
21C. Where is the copy of FIR?
Page number 7. 16.
What is the stage of trial?
That's it. Only the bail was rejected, that order should have not. Whether Sir Supreme or not.
So if the trial is not begun, we no point calling for the
And so,
LCR.
status report continue.
The let the status report of the stage of trial of
So registered order.
GR case number 153 of 2023, be obtained by the registry from arising out of Barpatha PS case number 20 of 23 under section 21C of the NDPS Act. Be obtained by the registry from the Court of Special Judge NDPS Karbi Anglong Difu. This one 8/11/2023.
NDPS case number, sir, NDPS case number 6223,
What is the number?
26, NDPS case number 63 of 23.
Acha, NDPS case number in respect of which in respect of which NDPS case number 63 of 2023 has been registered. Okay.
Date after
8/11.
it,
Item 5,
Pending for framing of charge. Pending for.
Pending of framing of charge. Okay.
Earlier rejection order is at least 94, 93. The part is placed 94,
94.
94. There are.
I think it should go to the same bench. It should go to the same bench. In view of the, in view of. As this, as the previous bill was rejected by order passed by order dated 13/6/2022 in BA 94 of 2022 by another coordinated bench of this court, comma, in view of the ensuing vacation, the registry shall obtain the consent of the honorable judge concerned and list the matter, any permitted, list the matter before the court today. Very good. Today, registry will check up if the court gives consent, then only. Okay. Registry कोठिया दी बनाई हूँ. Justice Bhattakur साहब, Honorable Mr. Justice A. Bhattakur.
the amount of order possibility.
कोई registry कोठिया दी बन. Registry consent है. So the record. Okay.
Whatever sort of restrictions.
मैंने सारे consent दिले.
Sare consent.
Yeah, not an I.
Item, supply item 32.
Apply page 17 last. Page 7 is that.
Just a moment.
The complaint.
Page
17 lots. This is Barney lot.
we'll have to call for the case diary here.
One six also pay really. Second one six also a next lot chip.
Page
Page lot chips. Page 32 is the Barney lot of chip.
32.
Lot chip.
No, so when the photographs are viral, we'll have to call for the case diary.
Case 30 lot, is the medical report of the victim lot. Case 30 lot chip. Bottom part lot chip in Assamese lot. মই 6 চনে ডাক্তৰ হৈ কোনো ধৰণৰ শাৰীৰিক আল্ট্ৰাছাউণ্ড আদি পৰীক্ষা নকৰো she has written herself lordships. And.
That's okay.
FIR was after
It's
2 months
okay.
lordship.
If there is a, otherwise an evidence available, you can't discard that. Not without a case
FIR was
diary.
after 2 months lordship.
No, no, maybe 2 months, maybe 5
And
months.
she's a married lady. I am the 20 years old lordship boy.
No, we don't know, but there's a allegation that videos were made and made viral. Correct. You may be the best of the persons, but we'll have to examine
And
the,
he's already in charge of their lordship. He's already in charge of their lordship already 39 days behind of our lordships. And my lord kindly see, the
he's arrested.
lordship. There is the lordship. And I already filed a bail appeal before the Lana Session that is rejected lordship. You also kindly see page 34. And operative price of page 35 lordship.
35.
Yes, lordship. And again, I filed a bail application that is page 36. There is another bail application that is also rejected lordship. The Lana Session that did not find any name on lordship. What purpose will serve lordship behind the past?
No, we don't know, but not without looking at the case diary.
Case diary. So
And this can fit for.
What purpose is something I can't answer.
64 and 164, she has fully implicated.
After
let-
2 months, she has loved the FIR lordships.
No, no, I said even after 2 years. But if a video has been made viral of a girl, this is something we'll have to examine.
And you will kindly see the following report. Nothing has been mentioned lordship. In the following report also. You will
We don't know, not without the case diary. When a photograph of a victim is made viral,
And here the law papers between them lordships. I have stated in my paper of lordship, category I have stated lordships.
no, very good. I also, what you call, have very good relationship with many people. In the bar also, I have got very good relationship with many lawyers. I was a lawyer once.
When the husband came to know about this.
No, it's okay.
Yes, lordship.
You see, if you turn around, I can name all of, most of them with which I am having a good relationship. Whenever I meet them, I say hello.
And I got the lesson. Lordship. I
Few-
already 39 days.
Few of the people I have visited their homes.
39 days went up.
No.
I got the lesson lordship.
No, no. But if it is a viral photograph being distributed in social media of a victim girl, nothing
And
worse
I
than
have
that.
done, but there is also only election lordship. That is.
No, we'll examine, otherwise we'll leave you, don't worry. Let the case diary be produced. The case diary scan copy be produced along with the alleged viral photograph, if any of the victim girl. List on 7/11/2023.
Can the spending before Lana Session that. Can the spending before Lana Session that all the lordship.
Charge sheet is submitted.
Lordship.
It's fine.
Lordship. I have a next lordship.
Where is the charge sheet?
Page 20 on lordship.
You have shown so many things you did not see, show the charge sheet. Yes, where is that? Page
20 on lordship. Page
15,
21.
21.
One photo is also seen. One photo picture containing. Second
Where-
picture of
where?
The victim on the Sarsit Lordship,
Page.
page number 21, number 2 Lordship. Description of the seized item. Down.
Acha. It is Information Technology Act.
Information technology.
Right. Yes. Again.
Slide code.
Madam Begum, look, I'm sending you something. On the flag page, read the last paragraph. Correct. There's an officer who can
Good.
do that. This year it fails. In your case, should be entitled to bail then. But Mr. M. Hawk transfer for the petitioner and Ms. A. Begum and the VP for the state. Next one, the petitioner was arrested on 10/9/2023 in connection with Sessions case number, the GR. No, it will be different. Sipajar PS case number 134 of 2023 under section 448 to 376 within packet 1 IPC. With added section 67A, sorry, 380 and 67 capital A of the Information Technology Act. Corresponding to GR case number 567 of 2023 and tried as Sessions case number 308 within bracket capital DM bracket was 2023. I have said arrested on 10/9, 10/9 arrested on 10/9/2023. Yes, it's paid for regular bail under section 439 IPC. The learned APP has opposed the prayer for bail on the ground that in the charge sheet it is reflected that not only the petitioner has sexually assaulted the victim, but her obscene photographs has also been circulated in social media. And one of such photograph has been seized by the police in course of investigation. Full stop. Accordingly, it is submitted that bail will be considered only on perusal of the case records. Next paragraph. On a consideration that the petitioner has already been in custody for last how many days? 39 days. And the case is already put up for trial. The court is of the custody opinion that further insertion of the incarceration of the petitioner in custody may not be required First, according to the court, is inclined to release the petitioner, namely so and so, on bail on his furnishing a bail bond of rupees so and so. I may make it 50,000 with one surety of like amount to the satisfaction of the London Sessions Court. Sessions Judge, where
Dorang Mangalega.
Darang Mangal Day. As a condition for grant of bail, the petitioner shall submit an undertaking before the London trial court along with the bail bond that he shall not default in appearing in the trial, and that in the event he is unable to appear for trial and for any compelling reasons, he would ensure that he is represented by his learned counsel, who would participate in the trial, including examination of witnesses and cross-examination. Of the witnesses. Yeah, make it two sureties, huh? Next paragraph. Out of the two sureties, one surety shall also offer his immortality as security for grant of bail. Next paragraph. In the will give other conditions. Next paragraph. The family member of the petitioner is permitted to visit the jail with a certified copy of the order so as to enable the jailer of the superintendent of jail, where he is presently lodged, to get the signature of the petitioner on the undertaking to be submitted before the London Sessions Court. Application allowed. Yes, 33.
Wait, this or not.
Yes,
Sir, this is a 239 application, my lord. But the case of the petitioner is that, my lord, the petitioner, my lord, is the secretary of an NGO. My lord. This NGO, my lord, on 17/7/2023, applied before the ADC Hojai for holding lottery, my lord, for collecting funds, my lord, for developmental activities, my lord. The application, my lord, is at case number 14, my lord.
yes,
On the basis of this application, my lord, the ADC called for a report from the officer in charge of the concerned police station. And the officer in charge, after making a field inquiry, my lord, submitted a report, my lord. That report, my lord, is at page number 17. The officer in charge said that, my lord, the situation under Jamuna PS is normal, so permission can be granted, my lord. So accordingly, my lord, the permission was granted by the executive magistrate Hojai, my lord. That permission, my lord, is at page number 22, my lord. That permission was granted on 27/7/2023. Hereafter, my lord, what happened, my lord, some sections of the society raised a complaint for holding against the doctor, my lord. So accordingly, my lord, that permission was cancelled on 20 September, my lord. That cancellation order is at page number 23. For cancellation, my lord, we were not given any notice and we were not also heard, my lord. Side by side, my lord.
just now.
Yes.
Yes, where is the cancellation order?
Page number 23, man.
Yes,
Hereafter, my lord, one PIL was also moved before this honorable High Court, my lord, for cancellation of the lottery, my lord. My lord will kindly find at page number 27, my lord. In that PIL, my lord, the petitioner NGO was made a respondent matter, respondent number 7 matter, but no notice was served matter. And after receiving the instruction matter that the district magistrate had already cancelled the lottery ballot, that PL was closed matter. Lordship will kindly see page number 27. The order dated 28/9/23 matter.
Yes,
After that matter, the lottery was held as per schedule matter on 30th September 23 matter. And on the same day matter, an FIR was lodged. That FIR matter is at page number 28. And the vernacular matter is at page number 22. May I read the FIR?
yes,
With due respect and humble submission, I would like to inform that the gift coupon claim to be held in Nigarimo by the Jungle Block Development Society on 30/9/2023 was cancelled by the order of the Honorable Guwahati High Court in White Memo number so and so of the district magistrate, and also an order that the cash collected from the ticket purchasers should be returned to the people as ordered to the President Sofiuddin Loskar and Secretary Kamrul Khan. Despite that, the President and the Secretary, by disobeying the order of the Guwahati High Court today on 30/9/23 at morning 8 AM, they conducted the gift coupon game in a mysterious way. Instead of Nigarim, they organized it at Vedavati in the land of this by cheating and committing forgery. Thus, after getting to know the President, Secretary, along with the below mentioned persons and committee persons and other persons associated with game, thereby proper action is to be taken. This FIR was registered under section 120B, 294A, 420, 468 IPC matter. Thereafter, the petitioner was arrested on 1st of October matter. That forwarding report is at page number 34.
okay, custodial mode detection is not required in these cases.
Already, this president was granted interim protection matter by an order of this court.
Okay, we are raising you. Heard Mr. S. Das, counsel for the petitioner, and Ms. A. Begum, running for the state. By this application under section 439 CRPC, the petitioner was arrested on 30/9/2023 and forwarded on 1/10/2023 in connection with Jamunamo PS case number 50 of 2023 under section 120 capital B, 294 capital A, 420, 468 IVC. Yes. Is praying for regular bail. Next paragraph. The allegation against the petitioner is that, notwithstanding that the permission to hold the lottery was cancelled by order of the Additional District Magistrate Hojai, dated 29/2023, the petitioner and others went ahead with the lottery draw in defiance of the said order. First, next one, on the said ground, the APP has opposed the prayer for bail, and it has submitted that the lottery is in contravention of the provisions of the what is that, Lottery Act?
Section 3 of the Lotteries Regulation Act.
Okay, section 3 of the lotteries. Within bracket regulation. Bracket was act. The lotteries, LOTTERIES, Lotteries Regulation Act 1998. Full stop. Be the as it may. I will consider the contents of the FIR as well as the order dated 29/2023, cancelling the permission to hold the lottery. The court is of the custodial opinion that further custodial interrogation of the petitioner may not be necessary. So accordingly, and the court is inclined to release the petitioner, namely so and so, on bail on his furnishing a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the learned Chief Judicial Magistrate
Was that?
Ojai. This will be, bail is granted on the following conditions. I don't condition that he shall appear before the IO once a month till his personal appearance is dispensed with or charge sheet is submitted, whichever is earlier. Yes.
Highly obliged.
You know,
Item 6.
no, there are few bail matters will take up that. And APP will be free.
তেনেকে বস্তুটো চাইছিলো বেলৰ মেটাৰিয়েল বহুত আছে
Oh, good, yes. Oh,
মানে
okay, 6 then. Durga Puja. Puja is already started. No, that is the what you call that is the festivities. That is the festivities, but the puja is already started from Mahalaya.
When puja will start?
Why should you interfere with the committee at this stage?
Pardon me.
Why should we interfere with the committee at this stage?
Lordship, the respondents, dependent lordship, they are creating trouble in managing the puja lordship. Every lordship.
No, you see everywhere, not here. Everywhere in the country, wherever I have gone or I visited, I find that wherever there is fund, there is a fight. Nobody fights for the being a committee member of the library. Correct. In Fancivilla, we have a library, Marwari Pustakalaya, but we don't get people to man the committee because it is a deficit
They're fighting for
budget.
posts mostly.
So nobody wants to come. People request, elderly people go and request someone and then they become the president secretary. For library, there is no one. Most neglected.
If lordship, an order is passed by your lordship, that simply that they will not create any disturbance during.
No, even for that, privacy finding has to be recorded that there is a disturbance. What disturbance, we don't know. It's a finding of
Or
fact.
my learned friend gives an undertaking that if it is.
No, this is very vague, not to create disturbance. You see, supposing there's an itching in my ears, I do it. Somebody will say, no, it's a disturbing element. In this meeting, why he should scratch his ears, disturbing element.
Here, lordship, the dispute is between the two rival committees.
No, I understand, but be specific. What do you want? Vague things in the court orders would create more difficulty than something.
They will, if the respondent agrees that they will not create any obstruction in celebrating the puja from Satmit to Vijay Dashmi. Thereafter,
No, what sort of? You see, I told you, these things are very, very vague.
from celebrating, solemnizing the puja festival.
No, puja, nobody will interfere. Everybody has fear of Ma Durga.
When they, this is one of the biggest puja being performed in Guwahati, Lord.
No, I understand, but see, in a puja, it's very hard to accept that somebody in the presence of goddess Durga would create a unruly scene, except for a few people who get inebriated and then habitually go there. Except for this few, what you call, exceptional people. I don't find that any Durga Puja, wherever there is even a quarrel, please be specific. I'm not averse to what you are praying, but please be specific.
The Lordship, they are disturbing in the construction of the pandal.
You are aware of the incident in Norway. In Norway, one Indian couple was found to have his girl child eat by hand. And therefore, that was taken as offense that the, what you call it, it's an indecent way of upbringing children. They have to eat with spoon and fork. And therefore, the couple was repatriated from Norway to India just because the child was eating by hand. And so far as I am concerned, I love eating by hand, not by spoon. And therefore, in retaliation, a political leader of our country went outside and had the entire Senate eat by hand, just as a protest that eating by hand is not.
I do not get any taste if I eat with a spoon.
No, that's why I'm saying it differs. You see, it's a perspective. Somebody thinks that eating by spoon is a culture. I think that if I eat by hand, it gives me more satisfaction, just like you said. So these things are vague if it comes in the court orders. As to what is a indiscipline, what is a disturbance.
If that order can be passed, that the respondent defendant will cooperate the petitioner in celebrating the. My learned friend agree.
I think you both of you go outside, have a discussion and come back.
We have already Lordship discussed. And
Yes, have you got a consensus?
Not really, my lord.
Because Durga Puja celebration,
Which group of people?
I know once there is a fund, there is a fight. There are two principles working. Number one, where there is a fund, there is a fight. And number two, my photo is my motto. These are the two elements where fight will occur. Why your photo? Why not my photo? I take it as a ego clash.
I mean, just with the background, what is actually happening? There are two rival groups. My senior friend's group claims that they were unanimously selected and they formed a committee. And they filed a suit and an injunction application saying that there's another group which has also formed a committee and that group should be injuncted from handling the.
That was rejected.
That was rejected. Now, my lord,
no, first of all, injunction was granted.
ad interim was granted, which continued for more than a year, and eventually the court said that it was rejected. Appellate court affirmed, saying that they did not approach with claim. Now the position is that our elected committee is already in place. In fact, we've already obtained permissions from the statutory authority. At this juncture, my lord, if your lordship, I mean, the order which is sought for, that we will not interfere. We will have to cooperate. They'll give a different meaning altogether. We are the valid committee. And in fact, my lord, we are celebrating the puja. So there's no question of we interfering with them. That's absolutely a different scenario.
Then we'll hear Mr. Roy on merit. I thought it can be settled.
No, but my trade is confined only to 5 days. That means to be Vijay, not beyond that.
No, give us an idea of what you are submitting. Yeah, I was trying to act as a Gambura to have a solution arrived. But since this Gambura adjudication has failed, now we take up on merit.
Lordship, the petition number 1 is a registered society under the Society Act here on. And it is one of the oldest organization, NGO, Your Honor, of Guwahati. And it is celebrating the Durga Puja, Lakshmi Puja, and having its own building at the school. Situated on facing both ES Road and the RP Road, Your Honor. So what happened, the petitioner number 2 Lordship, Ranjit Burman, he was the general secretary of the society Lordship till 27/10/21. So by issuing a notice Lordship, as a general secretary, he called a meeting for the AGM, fixing 27/10/21 for the meeting of the AGM Lordship. In that meeting Lordship, the agenda was for the production of the books of accounts and its approval, and for the selection of the new committee lord, which was duly signed by the then president, Sri Jatin Das. Now, your lordship, I am pleased to peruse that proceeding book lordship, that your lordship will find at page. Page lordship, that notice is page 69. Page 69. The notice which was issued by the then secretary.
69.
69 lordship, and actual 4. Annexure 5, page 60.
Page
Page 60.
69.
This is the agenda of the meeting lordship. Assumption of his by the president, 1 minute silence for showing respect to the departed soul. Preparation of the editorial report, there is typical mistake, secretary report. Comments of the members of the general meeting over the editorial report and the proposal. Expiration of old committee and formation of new. Speech by the general secretary. Then your lordship may come to the, originally it was issued in Assam, page 76. Page 76 lordship. This is the agenda, Your Honor, which was duly signed by the then President Jatin Das. Just below the agenda, Your Lordship will find name of the Jatin Das, who was the President, Your Lordship, and who presided over the meeting on 27/10/21. And at the bottom, also first signature, Your Lordship will find of Sri Jatin Das, left side, first signature, is the President of Jatin Das. The pleaded case of the defendant is this, Your Lordship, that the agenda was never, resolution was never signed by Jatin Das, the then president. But his signature is here, Your Lordship. Your Lordship may tell you the signature of the Jatin Das, then president, along with the signature at the bottom and serial number 1. Serial number 1 of the same page 76.
Yes,
Their Lordship, the General Secretary submitted his secretary report, General Secretary report, Lordship, in the said AGM. That Your Lordship will, because the pleaded case of the respondent is this Lordship, and findings of the courts below that on the day of AGM Lordship, the petitioner number 2, Ranjit Burman, was not the General Secretary. He was the President. Who the courts, learned trial court and the learned appellate court gave the finding that Ranjit Burman, petitioner number 2, as on 27/10/21, was the president and not the general secretary. And the learned courts below did not care to go through the pleadings of the parties in the documents, Lordship. All the documents show that as on 27/10/21, Sri Ranjit Burman, plaintiff number 2 or petitioner number 2, was the general secretary, and he submitted his reports in the before the AGM. Your Lordship, may please to come to page 82. It's Assamese vernacular is a page lordship. Page 86. Page 80. Original resolution is, report is in. Enacted 6.
Just on,
Page 86.
just on.
Also got.
No, just on, looking at something else. Yes, page number
Page 86.
86.
This is the General Secretary report, Lordship, dated 27/10/21. Lordship. Heading is from Padikya Puttivedar. So he submitted, he was the General Secretary from 2016, Your Lordship, till 27/10/21, Lordship. And at the next page, Your Lordship will find page 87. Ranjit Burman, Mukha Sampadak. Mukha Sampadak means General Secretary. But both the courts below found that no, he was elected as the president, he should sign as a president. He has signed as a general secretary until and unless the outgoing general secretary lordship took the charge of the new executive committee lordship as the president. He is not entitled to sign. He will, before till the day, only after taking the charge of the president, he will sign as a president. Not before that. This vital aspect was not considered by the learned courts below lordship and come to erroneous findings, lordship. Then this secretary report, general secretary report was accepted in the AGM dated 27/10/92. That resolution, lordship. What happened before that, lordship? This yes, Lord. It starts from page 69, lordship. Already 69 page I have placed with your lordship, and the resolution starts from page 72. Minutes of the page 72, minutes. of the-
Just a moment. Yes,
Page 72, Lordship.
yes,
Resolution starts of the AGM.
yes.
As per request of the General Secretary, Shri Ranjit Kaur, Shri Jatin Das accepted the position of President. At first, the members present in the general meeting expressed their condolences at the demise of the below. I'm skipping that. Yes, then the last paragraph. The members of the general meeting discussed the editorial secretary, it ought to be secretary report and gave proposal about the same. Members of the general meeting unanimously accepted the secretary ought to be secretary, I'm sorry, not properly translated. Secretary report. Dijen Deka stated that since 1942, due to the efforts of the various respected people, the Puja temple and its environment has been preserved. He requested that if they keep the legacy of the old members alive, then the present generation will get inspiration. And he specified that due to the outbreak of COVID-19, the situation of the people of the country has become very worrisome. The committee provided financial assistance to economic section. Jatin Das stated, we have financial assistance. We have gave the financial assistance in the past and will continue to so in future. General Secretary narrated the CA report of the past.
Those are not necessary.
No, not necessary. Then Lordship may come to in the middle, second resolution, past calculation and accepted unanimously by both member. The president of the committee resigned on behalf of the committee. So Lordship, it is a custom of Lordship that before selection of the new committee, the old committee president submits resignation letter. Accordingly, Jatin Das, Lordship, he submitted his resignation before formation of new committee. Then Lordship, by selection, Lordship, the new committee was for Lordship, President Ranjit Kaur, that is the present petitioner number of plaintiff number 2, for Pujal Khagan Das, the descendant, and other working president and the office bearer and the members were selected. And because Lordship, the constitution of the plaintiff number petition number 1, which is a registered society, does not provide for any election, only selection. Constitution, Lordship, I have annexed your Lordship, and that is also the finding in the informed order that there is no provision for forming the executive committee, Lordship, by election. That is not disputed, that findings have been given by the court in below. Then, Lordship, I would like to place the constitution. Very small constitution. Lordship, will be pleased to come to annexure 2, page 55.
55,
50, Lord.
50.
50, Lordship, this is the constitution of the Dispur Borobari Puja Committee Aru Jyotish Kala Kendra. Now your Lordship may come to next page, 51. On the left side, Lordship, in the middle, Karja Nirbah Committee Gothon. Karja Nirbah Committee Ajiban Kodasar Hadaran Koro Postiti Anushit Hadaran Sabha Gothon Koribo. Then Lordship may come to this period will be 3 years long. Then Lordship may come to the right side, Lordship. Lordship regarding the president. Lordship, Sabhapati Khamata. This is regarding the duty of the preside over the meeting. So lordship, nowhere, it is almost only 3 pages constitution lordship. Nowhere it provides for forming of a subcommittee due to election or ballot paper lordship. But the pleaded case of the respondent defendant is this, that there were some dispute or quarrel in the AGM on 27/10/21 lordship, and thereafter the supporters of the petitioner make hue and cry, and at the meeting could not be had. And no central executive committee was formed. And thereafter, the members, defendants, that is, they issued a notice that on such and such date, the election will be held. Lordship is aware that in any society, the notice is always issued for holding any AGM by the general secretary or secretary of the society, not by the members. In the present case, lordship will see that in what manner the respondents have acted, lordship, violating the provisions of the Constitution of India. Sorry, society. Lordship may come to page 88. Annexure 7.
Yes.
Page 88. This is a notice dated deal, Your Honor. No, this notice issued by the defendants, Your Honor. A general meeting of the Dispur Borobari Puja Samiti and Jyoti Kala Kendra was held on this date 27/10 to form a new executive committee in view of the expiration of the term of the old committees of Dispur Borobari Puja Samiti and Jyoti Kala Kendra. In the process of formation of a new executive committee, as per the agenda, 2 members were nominated for the post of president, but no decision was reached on the same. Since for other matters also more than 2 members can be considered. As such, the committee proposed to appoint the election committee. Therefore, in accordance with that, a 3-member election committee will be constituted by the following persons at a later date: Nirmal Vaishya, Bhadreshwar Tumu, Bhavan Singh Basumata. The above mentioned election committee has been given full authority in the formation of the Dispur Borobari Puja Samiti and making rules and regulations of the executive committee of Jyoti Kala Kendra, and the members of the committee will cooperate on the same. So this was notice dated nil was issued by the defendants, Your Honor, holding of the meeting for the selection of the executive committee, and 3-man election committee was formed by the members themselves, Lord. Then lordship may come to the lordship may come to page 99, annexure 8.
Yes.
This is the notice, lordship. Even in the notice, lordship will not find any date issued by the respondents defendant. As per the decision of the general meeting of Dispur Borobari Puja Samiti and Jyoti Kala Kendra dated 27/21 for the purpose of holding election of themselves of new executive committee, a list of 192 members was hung in the office premises. The general members are invited to report to the office of the committee within 29/11/21 if there is any suggestion on the list. And this was lordship, see the fraud or fraudulent action committed by the respondent defendants. Your lordship has seen that while the election committee was constituted, there were 3 persons. They are Nirmal Vaishya, Bhavan Singh Basumata, and Bhadreshwar Tumu. Here your lordship will see who has issued the notice, lordship, for Dulal Boro, election coordinator, and Pran Jyoti Bayan, election coordinator. just contradicting, and all these factual parts, Lordship, based on documents, were totally ignored by the learned courts below. So, Lordship, this is the, then Lordship, we come to page 101, annexure 9. This is also dated date, non-date. Page 101.
Yes.
Yes. This is the notice dated nil regarding the election program. Election of the executive committee of Dispur Borobari Puja Samiti and Jyoti Kala Kendra will be held by ballot paper as per the following schedule, subjected to the approval given by the general meeting of Dispur Borobari Puja Samiti and Jyoti Kala. Again, Central Committee, AGM, Lordship, the in the annual general meeting, this was never approved, number one. Election, then election office venue has been given, office of the society. Date of collection, this is very vital document here. Lordship. Date of collection of the nomination 1/12/21 and 2/12/21. Then date of submission of the nomination 3/12/21 and 4/12/21. The note candidate must be present in the person at the time of submission of the nomination paper. Then Lordship, serial number 3, date of examination and receipt of the nomination on 5/12/21. This your Lordship, be pleased to note that this date of examination and receipt of nomination paper was fixed on 5/12. And the election result was to be declared on at the last clause number 5. Election and counting 12/12/21. But Lordship, see, on the date on 5/12/21, which was a date for filing the nomination paper, the election results were declared. And that by whom? This note in next page, your Lordship, may please to note, page 101A, capital A. This notice was issued by Dulal Boro and Pranjyoti Bayan, who were simply the election coordinator, not the election committee member, Lordship. Election coordinators are appointed, Lordship, just to cooperate the election officers or the Lordship. They cannot discharge their duty in holding the election. They are just supporting staff. So this notice was issued by the persons who were not the members of the 3-man election subcommittee, Your Honor. Then Lordship. Lordship, may be pleased to come to page 103. 103, and this is the notification dated 6/12/21 issued by the respondent defendant, Your Honor, regarding the outcome of the election process. Your Lordship, may please to note the date 6/12/21, but the result date was declared as per the earlier notification 12/12/21. So they had shown that the election was held on 5/12/21, and this notification was issued on 6/12/21. And Lordship, may we please to come to next point, the next page 104, which shows that the election was declared on 5. Next page, Lordship. Whereas date for a scrutiny of the nomination papers filed by the contestants for various office bearers and executive members were done on 5/12/21 in between and found as follows. And the new committee was of the president, secretary, general secretary, members. And
Okay.
though the date was fixed on 12/5/12.
You'll have to sum up because today I have to complete everything by 4:30. You have to sum up. Make
Thanks
your
for
submission
waiting.
short.
Thanks for waiting.
No, but you'll have to make it short. I can't devote so much of time today. Because I have to sign and release all my signed orders by 4:30. Otherwise, if the section closes,
That it may be taken. There are many things, Lordship. here.
because if the section closes, then none of my orders will be uploaded.
Just one line, Your
Ah,
Lordship.
so you make summarize and
Lordship,
tell
the
us.
learned trial court gave the finding that the election held by the respondent defendant is defective and not legal.
The
The election result declared by the respondent defendant. Though my injunction application, earlier injunction granted was vacated, but it is on record that the learned trial gave the finding that the election held by the respondent defendant is defective and.
where is that?
Yes, Lordship. Lordship, may I come to the. Yeah, Lordship, page 199. It is start from page 199. This is the order by which Lordship, the injunction order was granted earlier in our favor was vacated. Your Lordship may come to the para 20, page Lordship. Page 20, Lordship, page 211. Page 211, Lordship, para 20. Per contra, the executive committee which was formed through election, as claimed by the OP, also appeared to be defective. And as on perusal of the constitution of petition number 1, this could find that this could not find any provision which proves the process of the election of the executive committee. Undoubtedly, there is a dispute between the parties regarding the formation of the executive committee of petitioner number, but at this stage, without having a full-fledged trial, it will be very difficult to opine that any of the committee formed by the rival party to be valid. In spite of coming, Lordship, because my pleaded case was that there is no provision in the constitution of the society, Lordship, for forming an executive committee, Lordship, by way of voting or ballot paper. So that was sufficient to find out the, to give the.
What is the finding of the trial court? Sorry, appellate court.
Appellate court, not Lordship, just cut and paste has been done, nothing. Just cut and paste.
Okay. Okay, I'll hear him because today I'm short of time.
I'll be as brief as possible. Lord, so the basic issue, the moot issue was what exactly transpired on 27/10/21. Now, there stand, if your lordship may take up page 114. 114. This is the most contentious issue as to what happened on 27/10/21.
This is plaint.
I'll just indicate one paragraph of the plaint and then the Ws. So para 6, my lord, at page 114, that in the said meeting dated 27/10/21, wide resolution number 1, the general secretary submitted his report, which was accepted. Wide resolution number 2, the accounts were submitted by the general secretary was accepted. Wide resolution number 3, Jotin Das resigned from his post, and the names of Ranjit Borman and Dizen Mohan were suggested for the post of the president, and the general secretary and Shri Ranjit Borman was unanimously selected as the president of the said society, and other office bearers and members of the executive committee were selected. So they claimed in the plain that they were unanimously selected. On the basis of these pleadings, they got an ad interim injunction. Now, our stand, your lordship, finds at page 155. For that, they rely on a resolution. Now, our stand is at page 155. The longest paragraph, I'll just quickly read it, my lord. That the statements made in paragraph 6 are totally false, fabricated, concocted, and hence denied by the answering defendant. In the said meeting dated 27/10/21, no selection of president and other office bearers of the executive committee was made as alleged in the paragraph under reply. As a matter of fact, the so-called resolution dated 27/10/21 is a manufactured document fraudulently prepared by inserting a subsequently prepared resolution indicating formation of a new executive committee over an attendance sheet. The plaintiffs must therefore be directed to produce a resolution dated so and so filed as document number 5 in the plain in original. On the fateful day, that is of 27/10/21, the plaintiff number 2, along with a few of his supporters, created an unruly environment by causing disruptions during the course of the meeting. Such disruptions were caused by the plaintiff number 2 in view of a recommendation proposal of the name of the defendant number 1 to the post of president. The plaintiff number 2 had been aspiring to hold the post of president and was agitated by such recommendation, fearing that he would not be able to garner support of adequate votes in the event of an election being held. Despite repeated insistence of the members to hold an election, the plaintiff number 2 and his supporters adamantly refused to convene an election and instead created a ruckus by raising irrelevant issues. Resultantly, owing to the continued disruptions, no resolution could be adopted and the executive committee could not be formed. With a view to secure an unfair advantage, the plaintiff number 2 and his supporters took forceful custody of the proceeding book, signed attendance sheets and other relevant documents and moved out of the meeting before its conclusion. The plaintiff number 2 had clear intention to avoid the formation of a new committee by way of a democratic process, since he was the incumbent chief secretary and wanted to remain in power. The plaintiff number 2 later on manufactured the purported resolution dated 27/10/21 by utilizing the said documents. The entire episode was captured on camera and was videographed by one so-and-so in a mobile phone. So on one hand, they say everything was fine. We got unanimously selected. We put up a case that this is what had actually happened. There was no election, selection, nothing. And you merely moved out by snatching the proceeding book. Now, the proceeding book in question, they did not produce it in original, which is why we had to file an application that the original be produced. Thereafter, the original was produced, and even from the photocopy, your lordship finds the proceeding book at page 76. During the injunction application, witnesses also were examined. Now, in the course of cross-examination, they clearly admitted that there was some manipulation. I'll show from the cross-examination that this was an extra sheet pasted on the attendance sheet, and the resolution was written subsequent to the meeting being over. So that this document was manufactured was virtually admitted by the witnesses in the cross-examination. Those cross-examinations, they have not annexed. I have a copy, though not certified.
Those things will be decided in the suit, lordship, not in the.
Because there was an ad interim, they wanted to extend it, and so as to delay it, they led evidence of witnesses. And during cross-examination, they admitted first of two things, two categorical admissions had come out. Number one, that he was not even competent to call the meeting because he was not even the general secretary. And secondly, that all was not well because there was disruption, and eventually he had moved out. Now, that bunch, if your honor takes up PW1, who is the appellant, Ranjit Borman, page numbers, second page onward. Prior to the third paragraph, prior to the meeting. Prior to the meeting dated 21/10/21, I was holding the post of chief secretary. There is no post of chief secretary as per the constitution of the plaintiff number 1, society petitioner. In the minute of the meeting dated 27/10/21, I had signed as the general secretary. I had called for the meeting on dated 27/10/21. It is not a fact that since I was merely a chief secretary, I have no authority to call for the meeting dated 27/10/21. One Shri Hogendas was the general secretary at the relevant point of time. One Shri Hogendas was the general secretary at the relevant point of time. The meeting dated 27/10/21. There was no election in the meeting dated 27/10/21, but selection was made. After selection, there was a dispute among us and Dizendeka. There are several persons who raised objection. These persons had demanded an election. They had proposed the name of Dizendeka as president and demanded an election, but no election was held since there is no provision in the constitution, provision of election in the constitution. Now, your lordship may skip over to the next page. The third paragraph again, an additional sheet containing the agenda has been pasted in the proceeding book. It is not a fact that addition sheet was subsequently pasted for purpose of filing the suit. The president has not signed the resolution adopted in the meeting dated 27/10/21. The president did not sign because I became president. However, I signed as general secretary on the same day, 27/10/21. I signed in the document number 6 annexed to the plain as chief secretary. Now, this document has been referred, relied upon by the friend, but only the translated version is shown as general secretary. The original version, even in this memo, shows as chief secretary. So now that answer was also there in our written statement that there was no post of chief secretary. One was selected and later on, just to sort of deal with the nominations, he was given an honorary post. In the
This is
this is the
this is which page here in the brief?
uh,
This proceeding book,
proceeding book is page 76.
76.
76.
This 76 is not proceeding book. This is a resolutions passed in the meeting dated 27/10/20.
Now, my lord,
Lordship,
we'll
the
just
proceeding
compare.
book contains many earlier resolutions.
It's an extra.
It is in the custody of the learned appellate.
Their entire case is, this is an extract of the proceeding book. Now, if that submission is recorded, then the entire case fails. Now, my lord, what I was drawing your lordship's attention to is page 85. This is another moot issue as to whether he was.
This chief secretary and general secretary, where is that?
That is only what I'm pointing out. Page 85, if your lordship sees.
Yes.
It's shown as general secretary, my lord, but actually the original copy at page 87, it shows Mukhya Hampador, meaning chief secretary. So,
Mukhya, maybe chief, maybe maybe
That's come
general.
up- That has come up in the cross-examination.
No, look,
That was the main issue because at times he signed as general secretary on 27/10/21 as Sadharan Hampador. And then in 87, he signs as Mukhya Hampador. Now, that is one of the major issues, whether because only a general secretary could have convened the meeting. Now, the witnesses also have said that no, Hogendas was actually the general secretary and I was only a chief secretary. That is admission your lordship has already seen. Now, again, the other witnesses also have reiterated that there was, some have said I was there was no post of general secretary. Some have said there was only secretary. But our clear stand regarding this entire dispute between chief secretary and general secretary was specifically taken, and that is something the court has taken note of. Now, regarding the selection, if your lordship will see the subsequent cross-examination of the subsequent witness, TW2, which probably will be page 15. Page 16, last portion. He was posed the question as to how a selection is done if there are two nominations. The last sentence, when two or more names are proposed for a post.
Page
16 of that.
16. Okay. Yes.
When two or more, the last sentence, when two or more names are proposed for a post, any member can select. However, all members need not select. there are roughly 92 members out of some members are tied. There is no concept of selection by majority. The moment members clapped their hands, the selection was done. We do not keep a count of how many members clap and how many did not clap for the selection of Ranjit Burman. I do not know which member has pasted the additional sheet in the minute book, both over the minutes of 27, 10, 21. The resolutions were written after the members had signed. So, my lord, which is why the learned appellate court has said that they have not approached the court with clean hands. Now, all of this entire episode that there was a demand for election, that they had pasted a resolution sheet, that there was there was a proposal for election by the members, was not even pleaded in the plaintiff. They simply said we got unanimously selected on 27/10/21. That is how we become members. Now, first of all, did the appellant number 2 revision petitioner? I'm sorry. Did he have the authority to call for the meeting?
But last line of the same page, it is not a fact that the resolutions were not written on the day of the meeting and they were subsequently inserted.
Yes, but before that, he admits that after the members had signed, 2 admissions, my lord, if your lordship, because of paucity of time, I'm not sure. My lord, if your lordship reads the 3 statements, the 3 versions of the 3 witnesses, this is sufficiently gatherable that this is what had happened. Now, all this entire thing was even, there was an annexure B which showed that there was a ruckus in the meeting almost leading to assault. That was also produced before the court by way of a proper certification. And that was also seen. And then, my lord, regarding the subsequent election which was called for, my lord, 2 things, my lord. If they say that the resolution of 27/10/21, that was actually not an attendance sheet, but was indication that the members had endorsed your finding. Those members themselves signed the other resolution whereby an election was called for. So, that again lends support to the fact that that was merely an attendance sheet and that did not really indicate the endorsement of the members regarding their alleged selection. And lastly, my lord, to address that issue which my learned friend has raised here, is that on 6/12/21, the election results were declared. Now, 6/12/21 is also a date figuring in the notice itself. That is the date fixed for withdrawal of actually, the difficulty is the typed copy is not the entire document. If your lordship finds page 105, the original, it is a little illegible. Why was it declared on 6/12/21 is there at page 106. 106, my lord, whereas today on 6/12/21, this is the date for withdrawal of nomination. In between 10 AM to 2 PM as stipulated, withdrawal of nomination by unwilling candidates from election fray was allowed. Accordingly, Mridul Varman, who filed nomination for contesting general secretary, withdrew his nomination on his own volition in Sweetwood. Moreover, candidates contesting for executive members, Parul Das and so withdrew their nomination under the given circumstances. Exercising our competence as so authority delegated found that no election was warranted. Now there is only one post, that is the day fixed for withdrawal of nominations. Now if there are only one candidate against one post, where is the question of there being a count? Well, this and page 106 is not a part of the typed copy, my lord. So I can produce a more legible copy, my lord. So that is the reason why it was declared on 6/12/21. Now coming to the my lord, the other part of it, at this juncture, My lord, your lord, we are aware that there, courts have consistently held that when an election is under challenge, there should ideally be no interim orders. Once they set aside the election, only then they may come back, probably. Now, secondly, interim orders regarding internal management, my lord. Now we are just, the puja is, actually puja is already come, my lord. In fact, we've already been given permission from the district administration to convene the puja. And that is also there, my lord. Now, under these circumstances, if your lordship passes an order,
This time goddess has come in which vehicle?
Lordship, everything we have done for.
No, not that.
Inspection. will-
Horse.
Horse.
Okay, understandable.
We are solemnizing Lordship, nothing.
No,
They
no,
had
that's
taken
okay.
the permission and we have lodged a complaint for.
There's a,
And nowadays, Lordship, our government has passed the order last month, Lordship, for any holding any puja, no permission is taken from any committee. That, apart from that, your Lordship, will please to.
I'll just.
no, just a moment. Let him complete his part. What is this?
This is the permission, my lord, granted by the deputy commissioner for holding the puja. Now, therefore, my lord, I cannot today concede to my friend's suggestion that I will give an undertaking that I will not. In fact, we would want a similar undertaking from them that we are organizing.
My friend was, you will cooperate him solemnizing.
Okay.
Now, your Lordship, regarding the dispute raised by my learned friend, that is the chief secretary or Mukti father. Pradhan.
No, it's not completed.
Fine. Now, my lord, so far as these internal management, I'll just quickly place three authorities, my lord. Of course, two are from state high court, my lord.
You just mark the paragraphs also.
Yes, yes.
You just leave that we. Okay, you need not read this because
These are
I don't have really time today.
Yes. So basically, these are only saying that like in the case of normal elections, legislative assembly elections, when an election is under challenge, they've already sought for cancellation. Now, there should not ideally be any interim order restraining me from discharging my duties unless my election itself is set aside, because that would amount to giving a final relief at the interim stage. On similar lines is the Supreme Court Bar Association case also. Now, my lord, even otherwise, given that this is a revision under 227, my lord, the trial court has decided the appellate court powers itself were restricted given the judgment of the Supreme Court. And now under Article 227, to enter into such a disputed question of tax, my lord, where there are two rival groups, perhaps at best, my lord, these are questions to be tried in the course of the trial. And granting an injunction either way, my lord, we've not even claimed one. So granting an injunction either way would give an undue advantage to the other side. And in fact, it is otherwise a very hotly contested matter. There are several applications pending where receiver appointment was also sought. Funds are being, there have been allegations and cross allegations of funds being misappropriated. So, my lord, let the puja pass in peace, my lord. The rest, perhaps the trial court will.
That's why I asked. Mr. Acharya said the goddesses come by horse. Now we can understand what is happening. Yes, Mr. Roy.
Lordship, how they are pleading of the respondents are. Lordship, not correct. Just your Lordship, please.
Just tell us quickly because Mr. Roy, I have to close this.
Then Lordship,
No, no.
will be taken after.
No, you just complete it. Your part, just make it short. I'm not asking you to stop. Merely I'm asking you is
Lordship,
to
come to page 108, please.
108.
108 Lordship with the plain. Now Lordship, just I place 2-3 paragraphs regarding my amendments made in the plain. Lordship may come to page 113.
113.
Yes. Para. 3. Para 3. That Sri Ranjit Gorgon, that is the petitioner number 2, was the selected general secretary as per the constitution of the society till 26/10/20. Then para 4, that being the general secretary of the said society, Sri Ranjit Burman had issued notices dated 19/10/21 to the members of the said society for holding the general meeting of the said society.
This you have already said. You have taken note of the dates.
No, but in the WS, they have not denied, but now.
Denied, my lord, 153, 153.
No,
Sign up.
no, yeah.
No, it's just okay. You make your
They have
statement.
not-
Please don't retaliate. Let me say
They
why
have
come
not
to.
denied it. They have admitted that the petition number 2, Ranjit Burman, before 27/10/21 was the general secretary. He produced the secretary report, duly audited accounts lordship. And then when the amendments made in para 3 and 4, lordship and 6 were not denied in the WS. Just one para of WS I would like to place before you. Lord, Your Honor, we please to come to page 153, para 6 of the WS. 156.
156.
Yes. That's all. Sorry, Lordship, para 153. 153.
Yes.
153, para 6. That the statements made in paragraph 3 and 4 that relating to gender secretary are matters of record, and the answering defendant do not admit anything which is contrary in process to the record.
Next line.
Yes, sir.
Next line.
Yes, it is pertinent to mention that the plaintiff number 2 at the relevant time held the post of the chief secretary and not the general secretary. Now, the chief secretary means lordship that as because in Assamese it is Mukho Sampadok, so he becomes the chief secretary. But in their WS lordship, they have stated that erstwhile chief secretary. That in the WS lordship, that para WS lordship is yes. Lordship will come to page 157. There WS 57.
157. Yes.
Last para. Subsequently, 18/11/21, an appeal notice was prepared depicting the decision, and the same was forwarded to all members, and altogether 85 members of the plaintiff society endorsed the same by putting their respective signatures. The appeal notice was forwarded by the plaintiff number 2 for obtaining his endorsement and signature. As the practice of the society, in the list of the signature, the president signed at serial number 1. The working committee president signed at serial number 2, and the serial number 3 was originally the chief secretary sign was left blank so that the plaintiff number 2 signed through being the erstwhile chief secretary. So at that time, Lordship, when the meeting was held, AGM was held on 27/10/21, I was simply the general secretary. As per their own admission, erstwhile. What is the meaning of the erstwhile? Previously, nothing else. And then Lordship, Lordship, page 157. 157. Para 10. That the Lordship, 157. In this regard, it is stated that on 27/10/21, the plaintiff number 2 and few of the supporters left the meeting midway after having created a hostile environment. The members of the plaintiff number 1 society thereafter resolved that since a consensus could not be arrived at regarding the formation of a new executive committee, the society would have to adopt a fair and democratic process of election for forming the executive committee. It was decided that all members, including plaintiff number 2, were allowed to participate in such election by filing their effective nomination, so that the democratic ethos be maintained within the society for the said purpose. It was decided that an election committee comprising of the defendant number 20, 21, and 23, that is 3-man election committee, be formed. But Lordship, while declaring the result on 6, as per the argument of my learned friend, result was declared on 6/12. And under the signature of whom? The coordinator, not by any members of the 3-man election committee, Lordship. So these are the irregularities declared on the face of the record. Apart from that, Lordship may be pleased to peruse the order passed by the learned trial court, full of contradictory averment, full of dates, Lordship, that your Lordship may just quote. Lordship may come to page 190,
190,
199, 199.
99.
If such type of order, Lordship, perversity is large on the face of the record, Lordship, it must be interfered by the appellate court. Just, Lordship, this is the judgment dated 18/3/23 passed by the learned trial court, vacating my injunction order. Just I will play the most relevant. Lordship, I come to page 208, para 60.
Yes.
Hence, from the pleadings on record, this court find that both the sides claims based upon the fact that the executive committee formed in respect of plaintiff number by way of rivals, by the rival parties are valid, undeniably the validity of the committee formed by the rival parties in respect of the petitioner number 1 shall be adjudicated on having a full-fledged trial. But prior to that, to decide the prima facie case, the court needs to consider the pleadings of both the sides along with the documents submitted herewith. The petitioner has submitted certain numbers of documents along with the plaintiff and also examined the numbers of witnesses before this court. This is one aspect of the matter. When the Lordship, it cannot be decided. The dispute can be decided in the, till then, it was the duty of the learned trial court to maintain the status quo as on that day. Then Lordship may come to page 209, para 80. 209.
Yes.
At this stage, last part, at the bottom, at this stage, without having formal proof of the documents submitted before the court find that there were 2 committees formed on, one committee formed on 27/21 and the another formed on 12/12/21. Where from the learned trial got this date? 12/12/20 was fixed for the declaration of the final result of the election. But as per the documents, Lordship, the result was declared on 6/12. There is no such any declaration of result dated 12/12/21 as admitted by my learned friend by submitting that the nominations were withdrawn by the other contestants. That's why the result was declared on 6/12. That was the submission of my learned friend. If that is the factual position based on record, where from the learned trial court got this date? There is no such pleading by both the. This was an absurd finding. Then Lordship, made it further.
Yes.
Now coming to the procedural aspect of the formation of the committee, this court on careful perusal of the documents submitted here, it finds that the petitioner number 2 claiming himself to be the president of the petitioner number 1. Petitioner number 1 file in the suit and perusal of the alleged resolution dated 27/10/20, it is seen that Sri Ranjit Burman was selected as president, whereas in the said resolution said Ranjit Burman signed as general secretary. This is also a perversity of hiding the law. Because your lordship, in any club or society, your lordship, when the outgoing body, that is the president secretary lordship, the term is completed for a election or election is there. And till the general secretary, in the present case lordship, the general secretary was elected as the president lordship. And he resumed the charge after the AGM was held. Before that, he was the general secretary. So he will sign as a general secretary. But the learned civil code did not know the difference between that taking only after taking of the charge of the president, he will be petitioner number 2 will be entitled to sign as the president. Before that, he is bound to sign only as the general secretary. So then, and perusal of the alleged resolution dated 27/10, it is seen that Ranjit Burman was selected as president, whereas in the said resolution said Ranjit Burman signed as general secretary of the petitioner. The petitioner number 2 has adduced to evidence of PW, and during cross-examination, he has admitted that in the minutes of the meeting dated 27/10, he had signed as general secretary. And he has called for the meeting on 27/10/21 and also admitted in his cross-examination that Sri Khoghen Das was the general secretary at the relevant point of time prior to the meeting dated 27/10/21, which is also beyond the contrary to the record. I placed the resolution. Khoghen Das was the only the treasurer, not the general secretary. Lordship, it is surprising that in the AGM, all the members, both parties, petitioner or respondents, lordship, they are not disputing the annual report, lordship, financial report, lordship. They are not disputing the agenda which was signed by Jatin Das, president, then president, lordship. So these things are not disputed. But lordship, the finding of the learned trial court that here the Ranjit Burman has signed as a general secretary. Of course, he had till then our pleading is on record that only in the afternoon, after over of the AGM, the petitioner number 2 become the president.
That we have noted.
Uh,
That point we have noted.
So there are many other things, lordship. Lordship, the page 210 line, para 90, full of absurdity, lordship. Page
200?
Page 210, same para, same page, para 90. At this stage, without questioning the validity of election claimed by both the parties, the court finds certain shortcomings from the case of the petitioner in respect of the resolution dated 2017. Furthermore, the scrupulous perusal of the resolution dated 2017, this court has seen some exclamation on the resolution like an extra sheet has been pasted in the proceeding room containing the agenda of election. Lordship, whenever lordship, just to save time when the agenda is notice is issued, lordship, just to, I am also representing so many society, just to take the agenda and paste on the proceeding room. But that pasting page learned both the courts below failed to consider, which was signed by the president Jatin Das. Already I have placed before lordship. So there was no question of any fraudulent action or ill motive, lordship. And see the lordship, the finding. Seen some resolution and extra sheet been pasted in the proceeding containing the agenda of election. In the agenda, there is no election matter, lordship. Simply selection of the executive committee. So all these, such a perverse finding were not interfered by the learned appellate court, lordship, and not only apart from that, lordship.
Mr. Roy, just give the paragraph numbers where you are intending to rely because I'll have to close it. At 4:30 is my deadline. If I don't, there'll be many people who will be
I don't
suffering.
know, I have got submissions and it will be taken after.
No. Once I have heard it, you just give me the paragraphs which I have to read.
Yes.
I'll do it.
Then that-
Just indicate the
para
paragraphs.
20
Don't
para
read it because I
20
don't have
para
time.
20 already I have cleared. for the laws.
Just refer to those paragraphs. I'll read it.
Lordship 27. Para 27 of the civil judge order. Page 212. Page 212, para 27.
No, in fact, I have already noted from para 16 onwards, I will be noting it. All the paragraphs.
Yes, sir.
16 onwards, we
Para
consider everything.
27. Para 27.
No, all the paragraphs are post paragraph 16.
31.
Ah.
31. 29, 31.
No, everything. We'll go through everything. Para 16 onwards.
Yes.
This is what you have
Yes,
said
yes.
earlier. So para 16 onwards, we'll go it completely.
And Lordship entire judgment, either of the trial court or appellate court, is based on misreading of the pleadings, Lordship, and misreading, lack of knowledge regarding the meetings of the society or of the club. President will sign Lordship when a next meeting will be called, executive committee meeting, then those resolutions will be read over to the members present in the second meeting, Lordship. And then only one big, if it is approved, then only the president who presided in the earlier meeting will put his signature as approved. It is surprising, Lordship, that being the member of the higher judiciary, they do not know the ABCD of the society meetings or clubs, Lordship.
Because we are not members.
Lordship.
Because we are not members of any society.
I am member of so many.
No. By the virtue of position I am holding, I'm not a member of any society. Wherever I was there, I had resigned. So I may not know. Okay, I'm closing it. I'll pass orders.
That's my written argument at page 190.
191.
I have also submitted it.
Where is that? Which page?
The annex, Lordship. That
Which page?
that is that page.
One 191 is the respondents, 181 is there. 181 and 190. My lord has retailed a copy of that cross examination.
Yes.
My written argument is page 180.
I have noted that. I flagged it in fact.
Whether your Lordship will again consider this case. Taken up.
No. Because then only if I can't complete this order today, only you will be the sufferer, but others, I will be able to upload all the orders. I don't know, I'll try my best. But really there is a shortage of time today. If 4:30, the sections is closed down. So, and our system has an internal server where it is uploaded and then the main server takes up and gives it in the public domain. It's susceptible to hacking. So therefore the main servers are always shut down or separated so that there is no exchange of data between the internal server and the external display. That's right. Okay, so continuing that after 5 minutes break.
And your Lordship will continue
Pardon me?
this matter.
No, not this matter. Yes, item 7.
I think 7 with 40.
Okay, item 7 and 40. Okay. Yes.
This significant petition lordship, I find again challenging the order of the appellate court lordship, that is civil judge Nagaon lordship. May I just directly go to the interim order lordship? Page number lordship 78. Annexure 8.
Temporary injunction was rejected.
Rejected.
Where is the trial court order?
Lordship, could find
You are the 24 defendant.
for the plaintiff lordship.
Yes.
Lordship could find it at page number 54 lordship.
Page number
54.
54.
Annexure 5. May I just read for
You see, but in this case, they are finding by both the courts that although you have a land, one cut of land is a government land in front. And therefore, both the courts have arrived at finding that that part of the government land was encroached and the house was constructed. So that part, we can't stop it. It amounts to the bar under 41A. We can't do anything. Huh.
Finally, read the judgment. Also, to save time, only the operative part also.
No, whatever you, since it will be your residential house which will be affected, you present your case.
Also, I'm just start reading from page number 81.
81.
I have got grounds raised in the member of the, I have heard that counsel for appeal for the appellate. On perusal of the LCR, it transpires that the petitioners as plaintiffs have filed mixed case number so and so against the opposite parties praying for an injunction restricting the opposite party from demolishing the dwelling house of the plaintiff in the suit that has established schedule A of the petition till disposal of the main suit. The case of the appellant as disclosed in the LCR is that the suit length measuring 4 kattas, 1.5 kattas lectures are described as schedule A below in the petition belonging to the plaintiff, which is the petitioner inherited from the father, late Harichan Deka, where the plaintiff resides with their dwelling houses, which is a 2-story building covered by holding number so and so, ward number so and so. This building was constructed over 20 years back gradually and now resides in the said building the plaintiff with their family. That prior to that, there was a Assam type house where the father of the plaintiff, Harichan Deka, resides with his family. The appeal party number 1, 2, and 3 are in the name of the extension of the breadth of National Highway 26 issued a notice dated 5/9/2019 and 25/11/2019, calling for the plaintiff to demolish the RCC building as the building falls in the so-called one lectures of government tag number so and so. That the alignment of National Highway 36 is not in its original position as the portion of the land already under erosion of Morikolam Bill. The said NH 36 has been created in the early 1970 and it was a narrow PWD road known as Doboka Road originally. There is no roadside land after extension of breadth of the said NH 36 in front of the residence of the plaintiffs. The work of extension completed a few weeks back. The extension of breadth of the road covers up to the roadside reserve land, where the road was originally narrowed down. The narrowed roadside reserve land was visible. But after extension of breadth, the roadside reserve land was included inside the road. There is no roadside reserve land in front of the plaintiff's residence now. The defendant now wants to plant a construct drain in front of the plaintiff's residential house, and for which the construction of drain, the opposite parties defendant have issued notices to the plaintiff petitioners that they are the plaintiffs have encroached 1 lectures of government land, for which notices were issued to the petitioner to demolish their 2-story RCC structure. That their house is situated in the same place in the periodic patta, and as such, there is no necessity to issue notice to them for demolishing the RCC 2-story building now possessed by them as their landed and their own landed property.
that due to the adamant attitude of the opposite parties at the moment, their RCC building may be demolished by the opposite parties arbitrarily to fulfill the so-called construction of drain and in so-called roadside reserve land of tag number so and so. That at this moment, the opposite party may demolish their dwelling house in the capacity house in such case, the purpose of the main suit will be frustrated. The points arguments put forward by the appellant side. Learned advocates also appearing on behalf of the appellant vehemently submitted that the learned court at the time of passing of the order dated so and so heard in law and not following the prayer of the petitioner. The learned court, the learned advocate has also further argued that the trial court ought to have given injunction as the petitioner has established three golden principles of injunction, but instead of granting the injunction, the learned trial court confused the matter by clubbing it with the public interest and rejected the prayer of the petitioner. Now, Lordship, if I may stop Lordship here, and Lordship may kindly see the prayer made in the plain Lordship. Plain Lordship would find a page number 36 Lordship. And page number 41 Lordship. A decree be passed declaring right, title, and interest of the plaintiff over the suit land as established in Schedule A. Number B, a decree be passed restraining the.
Yes, just a moment. Very good, thank you.
Number B. A decree be passed restraining the defendant from demolishing a plaintiff's residential RCC two-story building by issuing permanent injunction against the defendant, where the building is covered by holding number so and so, ward number so and so under the Nagaon Municipality Code is situated over the suit land established in Schedule A of the plain. A decree be passed not to give effect to the notice heading number so and so dated 5/9/2019 and 25/11/2019 respectively as given in the Schedule B below. A decree for cancellation of the said notice issued by the Circle Officer, Southern Revenue Circle, Nagaon, heading number 5/9/2019 and 25/11/2019. Lordship, in this case, there is three prayers, Lordship. First prayer is for right title interest over the suit land, Lordship. Number two, Lordship, restraining permanent injunction against the defendant from destroying that part of the house, Lordship. And number C, Lordship, the cancellation of the three notices. Now, keeping in mind the prayer, Lordship may kindly go further with the what has held by the court below, Lordship. Page number 83, Lordship, where I have left, Lordship. The learned counsel appearing for the opposite parties has submitted that the lower court has rightly rejected the injunction prayer as matter involves public policy at large. The petitioner has enforced on government land, and if the injunction is allowed, then it will hamper the general public. Now let us see whether the civil judge number 1 Nagaon has committed any irregularity or heard in law and facts while passing the interim order as alleged. The granting of temporary injunction is a matter of discretion of the court. The discretion is to be exercised judiciously according to the well-settled principle. Rule 1 of the order 39 of the CPC provides that there is a where in suit it is provided by an affidavit or otherwise that any property in disputed in a suit is in danger of being wasted, damaged, alienated, or any part of the suit or wrongfully sold in is of a decree. The defendant threatens or intends to remove or dispose of his property with a view to destroy his territory. The defendant threatens or disposes the plaintiff otherwise causes injury to the plaintiff in relation to a property in dispute, and where the court is of the opinion that the interest of justice so-called required. The conditions for grant of temporary injunction are as follows. In the case of Kashinath Santhan and versus Srimad Sudhindra Swami,
In order to grant an injunction, the party who seeks for injunction, party who seeks for grant of such injunction has to prove that he has made out a prima facie case to go for trial. Balance of convenience is also in his favor, and he will suffer irreparable loss and injury if the injunction is not granted. Lordship, then the skip lordship or his lordship, then lordship will just come into page number 86, lordship. These are the general principles that have been discussed, lordship. And then page number 86. In Meet case number so and so, the learned civil judge number 1, Nagaon rejected the prayer of the petitioner by stating that the petitioner has not succeeded to make out a prima facie case to get an injunction. From perusal of the order of the learned court, lower court, and from the documents annexed to it, it appears that the petitioner did not raise any objection before the circle officer Nagaon against the claim of circle officer or notice dated 5/9/2019 regarding encroachment of 1 acres of government land on the petitioner. The notice of the circle officer mentions about encroached land measuring 1 acre and vacating the said land by demolishing the RCC house standing thereon. The petitioner nowhere in his petition, the petition dated 6/9/2019, objected that they are not in excess possession of the land or they have not encroached the land of the government. They only sought time for execution on medical for execution on medical ground. Later also, they did not approach the concerned circle officer, objecting to the claim of the circle officer Nagaon by notice dated 5/9/2019. Whereas the opposite parties were able to show through their documents that the petitioners are encroachers of 1 acre of government land, but the petitioner in return has failed to adduce any kind of documents or evidence to show that they are not encroachers of government land as claimed by the opposite parties. So the petitioners have clearly failed to show prima facie case in their favor. Now, lordship, is this correct? I am served with a notice and I approach the court. In the meantime, I seek time on medical ground. Now, is that reason to deny a prima facie case? Is that the reason for a court to hold that I do not have a prima facie case when I am challenging the notice itself? As lordship has seen in the prayer, lordship, I have challenged that notice. Now, is court, in my humble submission, the court could not have held that I do not have a prima facie case, maybe on some other grounds, but not in this ground, lordship. That the notices, I have not referred to the notices. This is this cannot be, lordship. Lordship will further read my word. As discussed in the above mentioned paragraphs, the grant of injunction is within the discretion of the court, and as such, discretion is to be exercised in favor of plaintiffs if it is to be proved to satisfaction of the court that unless the defendant is restrained by any order of injunction, an irreparable loss or damage will be caused to the plaintiff during the pendency of the suit. The learned civil judge Junior Division Nagaon has, while discussing the principle of balance of convenience, has clearly mentioned that 1 acre of roadside government land for reserve tag number so and so, which is adjacent to the patta of so and so, which is required to be vacated for the interest of widening and strengthening of the road, which is going to be a public road. So if injunction is granted in favor of the petitioners, then public interest will be affected because government plan to widen the road for use of general public at large. In the state of Assam versus MS Associates, where it has been held that when a question of injunction arises, not only the 3 ingredients of grant of injunction should be considered, but it is in addition to it, the public interest or public policy also is to be considered. If injunction is granted affecting the right of the community in general, it will be dangerous precedent, and the court should not easily succumb to such prayers. Now, lordship, pausing for this moment here. Whether the question or the prayers made by the petitioner is in public interest. Whether the injunction sought for is for public interest. I am seeking declaration of right title interest over my patta land. I am saying that I have been living from before independence. Now, in course of time, roads widened. Near my home, the road has widened in last 1 year. When the roads will keep widening, whether they can say that this is all land which is near the roadside are government land. And without there being a trial, the court could have come into a finding that there is a public interest involved, especially when my prayer is for declaration of right title interest over my land. Not their land, not the road. I'm not claiming that road to be my land. Now, if there was a.
No, you are claiming title over the government land.
No, no,
In the schedule, you will find one Lesha Dag number.
that I
So that is a government land.
that I understood, Lordship, that is their Lordship, but assuming that not be there, I am claiming my right title interest over my land or the scheduled land, I may not get it. At the end of the trial, I may not get it. But whether that is of public importance, the whole road has been existence from time immemorial, and also my land. Now they are widening the land. And that time when I was in possession of the land, that time there was no state of Assam. Neither there was any public PWD department. They came later on. They made their own rules. They made their own dags and pattas separately. Now, after the entire procedure which is gone through, the land which I have been possessing for so many years, could they say that that's a government land? Now, that is the question that is left to be tried. Before that, if the court says that I do not have a prima facie case and that is of public importance, where would I succeed in this case? They have tried me in an injunction. In an injunction, almost they have tried me as if it's a main suit hearing, without looking into documents, without there be a trial in the case.
Yes, Mr. Khan.
It's clearly proved in the lower court lordship, one some such land belongs to the government. We need that land for the, we didn't need the PWD rule. Government doesn't want to occupy the land of land. It's the one kata some lots of land belongs to government land.
No, only one Lesha.
Lots. So we need that one lots of land. The findings of the lower court is clearly stated there.
But finding of this honorable court lordship is not correct. Finding of the court below, both the court below, is not correct. It's my humble submission, lordship, and looking into it, lordship. Without there being a trial, they are saying that, and prayers has not been looked into. When this is a form of a private dispute with the PWD department.
Okay. Consider and pass on this.
There is an IA also. I don't know 40.
Item 40, is it IA?
Yes.
Okay. We dekha for the petitioner and Mr.
TR Gogoi.
A.R. Gogoi,
120.
T.R. Gogoi,
TR
government advocate appearing for the respondents. Okay.
Hello.
Item 8. Item 8.
None appears on call for the petitioner. Is A. Begum under APP is present with the case diary.
Lordship's motion. Motion.
No. It's not come up for motion. Item 8.
I can make that.
No. Here is. It,
Bail hearing starts from lordship, I think.
no, I don't know.
For lordship, yeah, one
Huh.
order is there, I have also seen that,
Huh.
but it is, came in the motion list actually.
No, I don't know, but
Yeah.
just look at the order. It says you are present with CD.
They have reflected in the case, was with the motion.
Check up. Check up if you have a CD, we'll take it up at 2 o'clock.
The lordship, we have not received the CP.
Huh?
We have not received the CP.
No, because the court has recorded. The court has recorded without. You verified, huh? 2 o'clock.
8 to 80.
9.
Item 9.
None of you is on call for the petitioner. The petitioner, how is A. Begum and APP is present. Next, the petitioner was unrepresented when the matter was previously called on 4/10/2023. So therefore, it appears that the petitioner is not interested to, petitioners are not interested to pursue this application. So the application stands closed. Non-prosecution.
Item 10.
Find the FIR page 13. The FIR was lost by one operation manager.
Page
Page 13. if you want to read.
13.
Where is the FIR?
Just. Yes.
Page 13. I so and so. I am working on operation manager in ABC Logistics, Guwahati. It is informed you that we hire one vehicle number so and so vehicle from Karthik Roadways Corporation, Guwahati, Krishna Rai so and so, and his owner Surinder Singh, contact number. We have been taking vehicles hired from this broker since July 2023. Our transport tender is Tata Consumer Product Limited, Guwahati from July 2023 to June 2024. Driver name is the accused, not this verification. He would be Sheikh, so and so his address has been given as Koira Bari, Part A, Koira Bari, District Dorong.
Yes.
The vehicle number so and so was loaded from 93 Goripur, Guwahati to Kolkata on dated so and so. On our LR number so and so, right, so and so, our seal number was, that has been mentioned. This vehicle was load 530 raw tea bag, total weight 17,600 kg and the cargo. The value is approx 30 lakhs. We called the driver on dated so and so 2023, 18 September. Then driver asked us vehicles stranded in Kolkata DCPL, parking, waiting for offloading. Then we again called the driver on dated 19 September 2023. And then driver told me vehicle has been offloaded. Dated 29 September, 4 o'clock, we received call from DCPL Kolkata warehouse that where is your vehicle? Your vehicle is not reported there. After we got call to driver, then his mobile was switched off. We immediately called the broker. Karthik Roadways, then he said driver mobile is switched off. So this is the allegation, lordship. The driver, his mobile is switched off. In fact, the roadway, the Karthik Roadways Corporation, they could not provide the details of the driver. The FIR is lost against Rahimuddin Sheikh. The present petitioner, lordship, he is not implicated in the FIR, he is not named in the FIR. In fact, he is not connected to the offense. He is a resident of Dhuburi district. And the accused petitioner.
We produce the case diary, will give an interim. He's not the FIR named accused. Mr. R. Bora, counsel for the petitioner and his Begum, APP for the state. Next para. Apprehending arrest in connection with Changsari PS case number so and so. Page 1. Application for previous bail under 438 CRPC. Let the case diary be produced on the next date of listing. Next paragraph, having considered that the petitioner is not the FIR named accused, and considering that in the FIR, the allegation is that the driver has vanished with the cargo of 17600 kg of tea valued at about rupees 30 lakh. Value of 30 lakh, and there is no reference of the applicant in the case diary, sorry, in the FIR or the court. Despite objection made by the ABB, the court is inclined to grant interim pre-arrest bail to the petitioner, namely so and so, on his furnishing a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting officer. Interim bail is granted on the following conditions. Interim bail granted following conditions. So that the petitioner shall appear before the High within a period of 10 days from today. List on when
Date 14 Lordship.
14/11/2023.
Item number 9 here also. I was in another book. Kindly take it off.
You're there.
Report those for-
Report was called for Lordship, whether the FIR was registered or not, but we have not received the report. Lordship. It was sent on 29/9 Lordship. Message was sent from our office Lordship on 29/9. Whether FIR was registered or not, but we have not received Lordship.
What is the allegation? Where is the FIR?
No FIR Lordship.
There number 3 and 4 I have stated. Allegation is that my lord, log of the petition number 2 has lost some FIR. Because the police station.
You have a dispute with your wife,
Wife of the petition number,
wife of petition number 2,
petition number 1, sir.
petition number 1.
He lost some FIR in the police station, alleging some allegation under section 498.
498, I don't think you'll be arrested. There's a Supreme Court order. You can't be arrested like that on 498A.
Lordship. So what Lordship, we are not getting the message, the status report Lordship, whether it is.
We'll give you an interim protection because of this holidays. But we say that only in 498A or any limiting to 498A or any allegation made by the wife of petition number 1, and in no other matter. We are getting limited protection only in the FIR of your wife, not for any other matter.
They are the related family member.
Okay. Heard Mr.
There,
A. Rahim
Rahman.
Rahman, Learned Counsel for the petitioners. It has been alleged that the police personnel are searching for the petitioners, but they have not been able to track any FIR lodged against them. In the Dharamshala police outpost under Dhuri police station, it is apprehended that as the petitioner number 1 has a marital dispute with his wife. And there is every possibility that the wife of petitioner number one, namely, what is the name?
Zahidul Islam. Zahidul Islam.
No, that is the husband name, wife's name.
Rohima Begum, my lord. There are
Rahima Begum, wife, the daughter of
daughter of Abdul Hamid
Abdul Hamid,
of
may have lodged an Azhar with the Dharamshala police outpost or at Dhubri police station. This court by order dated 14/9/2023, which was reiterated on 29/2023, 28/9/2023, and 4/10/2023. Sorry, not 4/10, 28/9/2023, had requested the learned review to obtain a report from the concerned police station as to whether any case has been registered against the petitioners or not. First off, however, Ms. A. Begum, the DPP, has submitted that although letter has been written by our office on 29/9,
It's 21/9,
21/9/23 and
29/9.
29/9/23, seeking the information, but the information is not received. First off, in view of the considering that the courts will be on a long vacation, from 2010/2023, the court is inclined to grant interim fairness bail to the petitioners, namely so and so, limited to offense, if any, registered on account of complaint made by Miss so and so, daughter of so and so, wife of petitioner number one, or by any of her family members relating to matrimonial dispute between the said lady and the petitioner number one, the petitioners would be released on bail, on furnishing bail bond of rupees 20,000 with one surety of like amount, each with one surety of like amount, to the satisfaction of the arresting officer. First, it is made clear that this bail is only in respect of disputes arising out of matrimonial discord between the petitioner number one and his estranged wife. And this protection would not be extended in respect of any other offense. Next paragraph. The interim bail is granted on the following conditions. He'll appear before the outpost or the Dhuri police station. Dhuri police station. Before Dhuri police station within 10 days from today. Following conditions. List on
It's on Lordship 10/11.
10/11/2023. This item 11. No, here will issue notice. We have accepted the submission of the London APP that notice on respondent number 2 is necessary. In the morning, we gave orders for Child Marriage Act. Same. This is from which place? Huh? Tamar Hat. Tamar Hat in Dhubri district. 10-11.
Then
Petitioner number 2 is Atar. Atar of the husband. It's a old number.
We are changing the definition of old, and I am the agreed person. If you say 50 is old, I think many lawyers here would stand up and say no.
Because they married early.
I have also crossed that age of 50. I don't consider myself to be old, except for a few white beards I have grown. 50 is not old. No, no, if you have participated in the child marriage, then you are one of the co-accused.
I clearly stated, because the father was against the marriage, they law. We have stated that.
No, no, but once this allegation of child marriage is there and POXO is added, we don't know, we'll follow the warning's order, no entry. No, I understand.
Petition number 1. Other.
Yes,
notice served lordship, then only after serving. the notice.
no, but against father, POXO will not be there. Say only child marriage. Okay, give an interim to the father. Number petition number 2. Interim bill, 30,000 with one surety of like amount. It appear before the high within 10 days from today.
I may be permitted to start.
That order will be there.
Lordship, in regarding to item number 8, lordship.
No, in this, what is the next date?
For this.
Population of case diary?
10-11.
10-11.
10.
Okay. 10-11. At that part, he'll provide a soft copy for transmission to the APP. Through the registry, through the APP.
So, please.
Yes, item 8.
Lordship, regarding item 8, lordship, there is a CD lordship in court number 21.
Okay.
So for another method, similar method, lordship. So
Okay.
it will be after petition lordship.
Just try, because if the case diary is here, you'll send back again, get it back. Even if there is a delay,
Then
we can take
petition-
it as a last item. You see, if the CD is available, no, I understand, but if supposing the court releases that case diary, and it can come before the court before 4:30, we'll take it up, and if CD doesn't come, if the court has retained it, then we can't help it, we'll have to adjourn it.
Then 26 we will bring it. That will be better, lordship. We will not.
No, you see, Ms. Begum, what I'm saying is that from tomorrow, the courts will be closed. Bail is normally treated as urgent.
Lordship,
So that is why if it can be brought,
lordship,
it is okay. But if the court has retained it, then we have no option, we'll adjourn it.
lordship.
Correct? We'll resume at 2. You are the plaintiff or the defendant? Plaintiff.
We filed a good matter for discussion, referring the principal respondent number 1 6 for making any other construction matter. Your lordship will find a order, your lordship's order, madam. That is, page 63, the lordship have asked this order. The WBC was filed by us, madam. In that order, madam. It has
Page
63, madam.
63.
Madam. Yes, madam. was disposed of, madam, vacating the earlier pay order. Number 1/10/2020. With an observation to approach the Supreme Court. $75. No, 75. The last.
Okay.
Thereafter, madam, we approached the court at Dorat, madam, filing the title suit. But along with the title suit, madam, an application under Rule 39, Order 39, Rule 1 and 2 was also filed. That is, madam, the trial court, madam, they passed an order. That order is at least 95, madam. While passing this order, madam, the trial court, madam, has given some conditions that your lordship will face 106.
Yes, okay.
Hereafter, whatever, madam, in the month of before 2023, December 1 to 6, what they did, madam, they are demolishing the old house. Now, madam, they face change of action as arrest, madam. So we filed an application before the that is at case, madam, 108. In that case, madam, we said that if there is an order passed by the court, madam, and there is no such order to demolish the old structure, we are on the demolition, madam. In that conditional order, madam, there is no such order that the court has granted permission to demolish the old structures. That order was passed when the construction was going on one part of the land, madam, not the entire plot, madam, one part of the land. Now, after my taking that order is sword, madam, they are now demolishing everything, madam. So we are agreed by that, madam. And here, madam, annexed the paperwork also, madam. The demolition people, see the color photo. They have also annexed the xerox copy of the photocopy at case 149, madam. The lordship also see this, madam. Can you see, madam? Yep.
No, you see, first of all, if it is demolished, how do you suffer?
Our share, madam. Our share is there, madam.
No, your share has got nothing to do, because you see that is the trial court's order.
Yes, madam.
It has said that your share will be subject to outcome of the result of the suit.
Yes, madam. But you are good. There, madam, if the lordship see at case 132, and you see the order, madam.
Because you see, Mr. Das, let us say you purchase a flat. And in the flat, you want to, what you call, although there's a litigation going on, you have been permitted to, what you call, furnish the flat. Now you want to demolish one almirah and construct another one.
But that order was passed when this simple single houses constructed. So, now their order they have taken as a sword, they are removing everything. That I mean, because so a face for the action has arise. So we filed an application. That application is still pending before the court. This is the second application. The next date is on 29th of November. At least still that day, your lordship may have done set of stone. That's why everything will finish.
No, you see, in the first order, I've not been able to grasp the facts. Number one, the trial court has allowed the respondents to make construction, correct? So if they make construction and in the process, if they have to demolish something, how can you maintain a petition for injunction?
That order was given when a simple one part of the building was constructed. After passing this order, they are removing everything. That's why we are agreed. But we will also challenge their order. In the meantime, we
No,
will
Mr.
also
Das.
challenge this order.
You see, when construction is permitted on the land, that means some iota of right they have been given.
Yes, ma'am.
It includes the right of demolition. It can't be that the house can't be
That
demolished.
order, demolition has not been granted. Demolition was not there. I think demolition even goes on demolishing. But we have a sentiment in the Khafara. We are daughters, madam. We are daughters. This is our daughters. We have a right, madam. They are defending our right, madam. Saying that no, you are not entitled for that. But we got in that place, madam. They are demolishing that house, madam. We have a sentiment, madam, for that. Sentiment is also there, madam. People also see, madam. We are girls, but we stay here and
You
here,
see,
madam.
there's a difference. You move in. I'll give you an example, which I'm good at. Number one, you move around Calcutta. Many people have sentiments and you'll find the house in a dilapidated condition. They won't paint. They won't restructure it. Everybody says, no, I was born here and therefore this should not be colored. The color which was put in 1947 is still there in some houses. But that can't be the consideration. The consideration for an injunction is only three.
But one factor also will appreciate, madam. In a joint property, madam. In a joint property, madam, possession of the.
No, this property, number one, it belongs to the government. The property belongs to the government. And so insofar as the government is concerned, you make them only a pro forma defendant.
Since, madam, we have.
And you are asking for declaration of a right without claiming any relief against them.
But we have applied for settlement of our land. That's why government is a party here, madam. And morally uncommitted.
No, once you make a government a party, then you will have to ask relief against them because the possessory right, it will run adverse to the government.
But that is a matter of, that is different matter, madam.
No,
Since, madam, we have applied
no,
for-
that is relevant because of the fact that you see, two things. Number one, although I'm not proposing to say anything on that, but it is only the day as against the government also, you can show that their position is adverse. Once you make them pro forma, there is no relief against them. So the what you call possessory right against the government will not be granted. There's a prime facie view. I have not formulated my mind. It's only a tentative view. And if it is a case of what you call your application for settlement, then there are other authorities to do it. The civil court will have no jurisdiction. So therefore, how do you sustain your?
That story has not started, madam. It will start after this, madam. Once that start, madam, that why you are a first person or not, or not. It is second case, madam. The first case, madam, we have to get our own right, madam. Our right, madam, lordship will see the privilege, madam. The lordship, he had faced 34, madam. One thing we have not denied, that we are not the legal heirs of Imam Katan.
Just
That
a
we have
moment.
not denied.
Just a moment. Just slow down a little. Little slow. Voice. Volume. Where is your plane?
Minus 19 minus 19.
19. Where is your present injunction application?
I am another 3 to 1.
No, no. In this, the injunction application which was refused.
Appeal, 108.
108. And where is the order of the trial court?
Is 132.
132. 132 is only notice.
Yes, madam. Here, madam, the court has mentioned that there is a violation of, we are not in violation, madam. We are in remuneration.
No, no. Page 132 is only notice.
150, madam,
150.
the part in the 18.
Against the issuance of notice, you have gone to appeal. Yes, Mr. Bhattacharya, what do you have to say?
Lord, what my lord has just my lord was saying, has also been stated by the appellate order at page 152.
152.
Yes, there it is clearly explained why he is dismissing the appeal. So at page 152, towards the bottom, my lord, just to save time, I'm not making it.
Mhm. Hmm. 152.
Yes, page 152.
Okay. Which part?
Towards the bottom, my lord. This is the conditions. So, those are the conditions.
Oh, acha, conditions. Okay.
And after that, at paragraph 4 at page 153, I am reading it out. The respondent and defendant number 2, who are the main respondents, the remaining respondents are pro forma response. So that have crossed to the appellate court also. So that has been recorded by the. In the order, the appellate court, appellate court is silent about devolution. What happened to devolution? This order has not leaving my. That the first further action has arose. Devolution must be stopped. Otherwise, there will be multiplicity of the litigation, one after another. We are before a lawsuit since 2020.
Okay, let me consider. Let me consider and pass orders. But there may be a problem. If I can't upload the order, then you'll have to wait till the next reopening day of the office for the order to be uploaded.
After giving the interim order, stay order. They have engaged more than 30 numbers of labor per day. That's the problem, my lord. My lord, whether will be proper defendants or pro forma defendant, the word pro forma may be struck off.
No, we can't do that.
They will have.
We can't do that. In division, we can't say that jurisdiction.
It's government there. That is a fact.
No, but I'm not saying it. You have the notice, you have to take steps, whatever is required of the government. Okay.
There is two, one is for the injunction and another is for dispensing the repayment of copy. This court is closed, madam. So we have filed and for dispensing the production of a certificate copy, madam.
Okay. Okay, which is that I have for dispensing the certificate copy?
3219.
3219. Mr. SP Das, counsel for the applicant, and Mr. KK Bhattacharya and Government Advocate appearing for pro forma respondents. Next, this interlocutory application has been filed for dispensing with the production of certificate copy of the order as the learned trial court is closed. Post prayer is accepted. The production of certificate copy of the order, impugn order in the connected revision is dispensed with. Application stands allowed and disposed of. Okay. You just mark the paragraphs. But if I can't complete my dictation, viewing of the order will only be possible on the opening of the office. When is the office open? No, office, not court. Office is open tomorrow. Okay, then perhaps we'll get it tomorrow. Yes, 36.
Where did the lordship? This is a 438 information matter. But in this case, madam, there are 6 accused. Out of 6, madam, 5 has already been released on interim bail measure. And one accused number 1 is Tribunal law.
Jamilul Islam.
Where is the FIR?
FIR case, my lord, 9, my lord. And my lord, the operative part start from case 10, my lord. Translated by people. May I read, my lord? Operative part at case 10.
This appears to be a consensual relationship.
Yes, sir.
Mr. J. Ali, counsel for the applicant. And Ms. A. Begum, APP for the state. The petitioner is apprehending arrest in connection with page 2. Is praying for furious bail under section 438 CRPC. First one. It appears from the contents of the. I'll let the case diary be produced on the next date of listing, next paragraph. On a perusal of the FIR, it appears that the on a complaint made by the informant, the the present petitioner was arrested for having physical relationship with the informant. It appears that after the petitioner was released from jail, he again established physical relationship with the victim. Full stop. Under such circumstances, notwithstanding that the further allegation is that the informant was threatened or her modesty was outraged by other accused persons. There appears to be some element of consensual relationship and full stop. Therefore, the court is inclined to grant interim pre-arrest bail to the petitioner, namely so and so. It's 30,000 with one surety. Conditions that they appear before the eye within 10 days from today. Failing is this interim bail shall stand revoked.
1411.
1411 for case diary.
I know. 35
Oh, acha. 35 I missed. Item 35. This I missed out. Yes.
Can you receive on some search, but my one submission you receive. I have a citations. Your worship,
Which page is the impugn order? Impugn order is at which page?
interim order is at page your worship 171.
171.
And last. Election.
Yes.
Proceed. Is para 38. Small para. When the code below does not apply its mind to the provision of order 39(1)(3).
Paragraph
Paragraph 38 your also.
38.
30. Last. Where the code below does not apply its mind to the provision of order 39(1)(3), when it refuses to grant an interim ex parte injunction, it acts illegally or with material irregularity in exercise of its jurisdiction and in the division may lie. Under order 3(39), what the court has to see when requested to grant an ex parte injunction is whether the object of granting the injunction would be defeated by delay. In the present case, the court did not apply its mind to this aspect of the case at all. And of the facts of the case, I am satisfied that it was a key case in which ex parte injunction be. And in this case, your lordship, the appellate court, while issuing injunction, your lordship, has not applied his mind. The present case, your lordship, if the injunction is not granted, I am the owner, your lordship. The injunction is not granted, your lordship. What will happen, your lordship? They will change the nature character of the student, your lordship. I will discuss your lordship. So, and then trial court, even the appellate court has not applied his mind. And this amount to miscarriage of justice, which gives us the jurisdiction under 27. Moreover, your lordship.
Yes.
Your lordship, moreover, your lordship, in a Surya Devi, your lordship, and recently, your lordship, on the moment I heard. Your lordship, para 4. Third page, your lordship, para 4. Supervisory jurisdiction under 227 of the Constitution is exercised for keeping the subordinate court within the bound of their jurisdiction. When a subordinate court has assumed a jurisdiction, it does not have and has failed to exercise a jurisdiction which it does not have, or the jurisdiction, though available, is being exercised by a court in a manner not permitted by law, and failure of justice or grave injustice has occasioned thereby, the High Court may step to the exercise its provision. Then, your lordship, it is my land. My land was forcefully, illegally taken by the respondent number 1, your lordship. And therein he is constructing the wall, your lordship. The learned trial court as well as the learned appellate court has not gone to this, your lordship, how I suffer. So this part, your lordship, that the failure of justice, a grave injustice has occasioned thereby. So it is grave injustice occasioned to me, your lordship, my lands.
A stranger has taken over my lands. He's constructing there on your lot.
No, you see,
So it's given.
Mr.
my
Jha,
permission to
Mr.
show
Jha,
your lordship
there would be an
will-
interpretation required. You see what is happening. Let us say, for example, a court, competent court having jurisdiction has a power to grant bail. Correct. But bail is not granted. So can the High Court in exercise of jurisdiction or Article 226 or 27 say that no, bail should have been granted? You see, injunction is a discretionary relief.
Your lordship, but discussion has to be exercised.
No, it's not a question. It's a discretion whether to grant or not to grant. Even in good cases, we will not grant.
But your lordship, in this case, your lordship, if injunction is not granted, my land will be alienated. Even my land will be if it will change the nature character to them. Thing is that your lordship, I am the owner. From my face on record, I am the owner. I give
No,
my sale
you
is
see, you may have a good
there.
case, but what I'm thinking is a question of law. You see, can there be a mandamus by the court to another court saying that you must act in this manner? Because we can't give a circular direction that the application for injunction is there. If somebody says that I am the owner, give an injunction.
Your lordship, Surya Kumar is the first judgment, your lordship, where the honorable court has a jurisdiction even to substitute your lordship down. This is the judgment. I have shown yesterday, your lordship.
The past that I've returned it. I think I've returned it. Did- Did I return it back to you?
Your lordship.
Yes.
Just 25, your lordship. Para 25.
Which para was there?
25.
20?
25. Is it the distinction between implicit and implicit? I'm reading one part, your lordship, in the last part of this para.
Just a moment. Okay, please come to the merit.
Your Lordship, I have the honor of the suit land. To that effect, I have filed the said report. Page 24. Page 32. To study Your Lordship. Total length. Your Lordship, chief plaintiff has purchased the land by 3 series and filed the series. And this plot of land is conjoined land. It's forming a single plot. And Your Lordship, after purchase, I have mutated my names. My name appear in the Jamabandi. Your Lordship. Jamabandi is 51, page, page 51, Your Lordship. My name is at page 53. The serial number 27, 28, 29. 27, 28, and 30. So after purchase, I have mutated. My name is there in the Jamabandi. I am the Patadari. See, I was possessing them. Thereafter, Your Lordships, I am also paying the land revenue to authority regularly, Your Lordship. What happened, Your Lordship? Suddenly, one Vipul Pal, the defendant number 2, the respondent number 2 in this case, has filed a suit. Prior to that, Your Lordship, this respondent number 2 claiming that my land is his land. On that, Your Lordship, I've had an application before the circle officer for demarcation of the lands. And the notice was issued to the all concerned, Your Lordship, including this dependent number 2 and 1, Your Lordship, to be present for demarcation, Your Lordship. And this notice is at page, Your Lordship, 77. On the particulars. To stop the demarcation, Your Lordship, this respondent number 2 has filed his suit, page 83. Page 77. So stop this demarcation,
Which should at page
page 83,
83.
Your Lordship. Wherein
What is the number of the TS 10 or 23?
10 of 23. When, Your Lordship, page 85, Your Lordship, para number 3. Clearly stated, the plaintiff begged to state, Your Lordship, page 85, para 3. The plaintiff begs to state that the defendant, if can demarcated, being the land mafia, will sell the scheduled land to other person by depriving the plaintiff from his legal rights. I am the, Your Lordships, I have a held it, everything is there, Your Lordship. By this to thought that demarcation, he filed this. Interesting thing, Your Lordship, please, page 83, please see the, Your Lordship, the person who are made dependent in this case. By this case, Your Lordship, I have people follow fighting the case. One of the person is Keshav Sir. He is also the defendant in the TS 10 23. This person taking this advantage in proceeding. Now he is in position.
Keshav Sharma is in position.
Forcefully disposes me from the suit land respondent number 1. And now after dispositions, he raising the construction, I have shown the photography. or-
where is your blind?
Land is at phase 112. 100 feet. So my humble submission, your lordship, this Keshav Sharma, now by taking my land forcefully, raising the construction, to that effect, I have also filed your lordship photographs. My humble submission, your lordship. If this Keshav Sharma, the respondent number 1 is allowed to construct your lordship house or anything, your lordship, and it will alienate and do something, your lordship, I will suffer. It is my land, I am a patadar, there is privacy and the honor of it.
Mr. N. Jha and counsel for the petitioner. First off, by filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 29/9/2023 passed by the learned Additional District Judge number 1, Kamrup Metro Guwahati, in Misje case number 120 of 2023, in Miss Appeal number 25 of 2023. First off, by the impugn order, the learned First Appellate Court had issued notice on an application filed under Order 39 Rule 1 and 2, which was registered as Misje case number 120 of 2023. Next, it is submitted that unless the challenge made under section 115 CPC does not lead to the disposal of the concerned suit or proceedings, application under section 115 CPC would not be maintainable. And accordingly, he has filed this application under Article 227 of the Constitution of India. First off, by we'll just say here, issue notice returnable in 4 weeks, steps within 2 days. By registered post with AD, list after 4 weeks, then IA. But Mr. N. Jha, counsel for the applicant. By this application in under Order 39 Rule 1 and 2, read with section 151 CPC. In connection with the connected application under Article 227 of the Constitution of India, the petitioner has, the applicant has prayed for an ad interim injunction. So restrain the respondents, sorry, opposite parties from raising further construction over this wetland, which is described in schedule to this application. Full stop. By referring to the connected application committee submitted that the applicants had purchased their land out of by virtue of 3 sale deeds, and having taken possession, the land has been mutated in the name first of as the applicants found others claiming right over the land. They had applied for a demarcation of the wetland before the competent authorities under the establishment of the deputy commissioner. Which place?
Yes, 77.
No, which place?
Your Lordship, Sonapur.
Sonapur. Sonapur is Kamrup Metro.
Yes, sir.
Sonapur, Kamrup Metro. Kamrup Metro, Sonapur. Full stop. At that point of time, it is projected that the opposite party number 2 filed TS number 10 of 2023, claiming right over the wetland. And during the pendency of the said suit, the opposite party number 1 had disposes the applicant and has started construction of a permanent wall over this wetland, which is claimed to be owned by the applicants. Full stop. Explanation notice returnable in 4 weeks. Steps shall be taken within 2 days for service of notice on the opposite parties by registered place with BD. Next paragraph. Considering the nature of grievance expressed by the counsel for the applicants, they have been able to demonstrate prima facie case by producing their title deeds in respect of this wetland and copy of Jamanti showing that their respective names have been mutated in respect of this wetland, which is the subject matter of TS number. Your suit is TS number
Yes, sir. Case number 559.
559 of 2023, which is pending for disposal before the Court of Learned Civil Judge within bracket Senior Division, bracket close number 2, Kamrup Metro, Guwahati. Full stop. According to the court finds that the balance of convenience tilts in favor of the applicants. To prevent damage to their property, as the resume of construction by encroachment may lead to a possibility of the change in the nature and character of this wetland. And the same will lead to irreparable loss and injury to the applicants. Therefore, the court is inclined to grant an identity injunction till the next returnable date. Restraining the respondents from proceeding with further construction of the proposed boundary wall or otherwise changing the nature and character of the suit land described in the more fully described in this application as well as in the schedule appended to the plaint. Next paragraph. It is made clear that this order would become effective only on service of the notice of this application on the opposite parties. Full stop. Therefore, comma, the court also grants liberty to the applicants to serve notice on the opposite parties through WhatsApp, Telegram, or any email or any other electronic mode of service, and provide a proof thereof in form of affidavit before the court on the next date of listing. Next para list after 4 weeks. I just give a date when I'm giving an injunction, give a fixed date after 5 weeks. Okay. Next time, don't cite what you call Suryadev Rai. Suryadev Rai has been overruled. The decision I won't be able to tell you right now, but it has been overruled. Correct. 3-judge bench. The judgment is perhaps authored by Honorable Justice A.K. Goyal is in the Supreme Court. Yes, item 37. Yes.
Page 9. Page 9 is the FIR.
Just a moment. Nine.
Page 9.
Who are you?
I'm the owner of the kettle.
36 number of full of lot.
36.
Right. Purchase from the Akapara market. After Twitter, I filed an application before the land is sold before Zimba, and that was allowed. Now,
Where is your RC?
I'm the owner of the kettle. I'm
Owner of the cattle.
I have annexed the Salan of market.
Page number 43 lordship, where he has been allowed to take the hand over the cattle.
43.
43 lordship.
Second. Zimba was filed, that was allowed. Now, my acquisition general cases will be under notice. I may be taken into consideration.
Then give an interim protection then. Saki Barwa, counsel for the petitioner, and Ms. A. Begum Leonard, APP for the state. Apprehending arrest in connection with page 2. PRS building of 438. Let the case diary be produced on when?
Entry lordship, 10/11.
10/11/2023. Have you noted that that in this application, the petitioners have produced a series of documents showing that the cattle was purchased in the cattle market under Nagaon cattle market, namely Katpara, KATHPARA, under Nagaon Zilla Parishad. which was being transported in a truck. And 36 cattle were, numbers of cattle were transported in a truck. And on further, no, comma, and further considering that by an order dated 12/10/2023, comma, the learned additional Chief Judicial Magistrate Complement of Guwahati has allowed the petitioner to receive Zimma of the custody of the said cattle. Court is inclined to grant interim PRS bill for the petitioner, namely so and so. It is 30,000 with one surety of like amount. With the conditions, 10 days to appear in the before the IO.
Right.
List on so and so. Yes, item 38.
It's not the, we have the application, FIR page number 14.
You tried to chop off the ear and the neck of the victim informant.
কারণ কিছু জখম করে কিছু জখম I admit that some of targets and
No, but to move in a road in with a Naga Dao, that is something very dangerous.
very false, no Nagadao has been used. It is the statement of the allegation is clear.
No, because unless you look at those very good English movies where one can do what you call all those fight and then cut off people with their own bare hands. Without a knife, without a dao, you can't cut off at least ears. You can tear it off, but you can't cut it. So Naga Dao, if it is there, we'll have to call for the case diary.
It is by Nagadao.
No, we don't know, but if some people are chopped off on the road like that, not very healthy. In entire Europe and US, same thing is happening. People are being just sliced off. 2 days back, he was in airport, right? Which airport? A lady was stabbing innocent travelers. Oh, Mr. Fukan.
Everything here.
We'll get it. We'll get the medical report also.
I am ready to cooperate.
No. With people with Dao gun, they will not cooperate.
I will cooperate.
No. We don't have faith on people who are carrying Dao like that.
7-11.
7-11 for case diary.
Item 14.
Bail application under court agency object.
NDPS 21C.
Earlier it was visited lordship on
21C.
21C and 29 lordship.
I was order dated was 29/9/2023. My lord. These honorable for directed is my lord. Directed asked to my lord produce the after this. That's all. This honorable lordship, my order dated 29/9/2023.
Yes. Status of trial. Yes.
My lord, part to obtain instruction for the trial court.
No, because the IO will know. You see, now you have the CCTNS 5 charge sheet. You have the name of the IO. It is their duty to produce witnesses. Court will order, but it will be you who will be taking steps to summon the witnesses.
Lordship, as per my instruction, 5 of the witnesses have been examined out of 6.
5.
Out of 6 cited.
No, but still we'll have to get this. We'll get it from the court then. It is before which court?
From the court of the Lordship,
Huh?
additional session does number to Kamrup.
Kamrup Metro. But we'll have to postpone it till the opening date. Because nowadays, I don't know, I don't think the concerned police station can say that we don't know about the trial. Because whenever the court issues notice, it will go through the same police station for service. They will be knowing which witnesses have been produced.
Also, rest of the others can go to the well, can go with the answer. That will be clear everything.
Okay. No, I think in this case, you made us, the APP made a statement, but we think that once CCTNS 5 is there, there is every reason that the police station would be knowing what is happening in every case. Okay, next para. Sorry, both sides are represented. Mr. R.J. Barwal and APP has submitted that he has not been able to procure the status report of the trial. And he prays that the said status report be procured through the registry of the court. Full stop. Accordingly, and next para, Mr. N. Hassan, learned counsel for the petitioner, submitted that as per his instructions, 5 witnesses have already been examined. And how many are left?
Total of there are 6 cited. 6 cited. One,
6.
One is left.
One is, and there's one cited witness yet to be examined.
There is one on 111.
And the case is fixed on 1/11/2023. Full stop. Next para. The registry shall call for the status report of the trial of NDPS case number 5 of 2023 from the Court of Learned Additional Sessions Judge number 2, Kamrup Metro, Guwahati, corresponding to Guwahati GRPS case number 106 of 2022. The requisition will be sent by email with liberty to the said learned court to send the reply by email for being placed before the court. Next list on. It is opening on 6th, so I'm making it 7/11. 7/11. 7/11.
But you scan copy of LCR may also be.
Okay. No, I think it's available here.
No, there is also earlier.
So this is till when?
Lordship, March Lordship. Till that time, no PW was examined.
Okay. Okay. Number 1, number 2, a scanned copy of the evidence of the PWs. Others are available.
Public.
This is that Rajdhani episode.
S11.
S11.
Public.
Okay.
Item 15.
Your this case has led to many developments. This S11 has led to many development in the approach of the police in NDPS matters.
Some of the PW said that it is D11. The D is also not there.
It's okay. What has happened is happened. But I think you were there in that meeting.
Yeah.
I don't know whether it is good or bad, but some changes we think we will see in near future
Lordship, that is required.
in your case.
Public.
After your case, sorry, not in your case, but after your case.
439, they are arrested fellow on 28 and.
So just a moment. I'm sorry, Mr. Hassan is left. You take note of this submission and inform your authorities, the concerned police officials. Now the witnesses are saying D11. Yes, Gampura certificate.
petty method is, one is doing a small bread, another is a cultivator. They were arrested on 28/9/23, 21 days in
But
the FIR.
where is that FIR?
Find at page 14. The long one, it's page 16. Based on paper report, investigation was carried out by the defense side. And extensive inquiry was made. There they have found from these forest areas. These were well illegally, these were transported and some of the persons by setting up sawmills. The timbers are shown there and was the names are also given, but none of the prisoners' name yet.
Yes, what is there in the case diary?
There are some material against both of it, accused person also. So, but at this stage, I am opposing because there are some other accused person yet to be arrested. They are running this illegal business.
Fine, the
Just show that case diary.
forwarding report. In the forwarding report, some of the grounds they have mentioned at page 17.
No, I've seen that the illegal sawmills are being run. There are 5 or 6.
They said that we are only sawmills. These are selling those, it's not correct. We don't own any sawmill at all. This statement is made.
If it is illegal, it's very easy to deny the ownership, but fact remains that in the riverbank, this is Dibrugarh, I think.
Bank.
Not Dibrugarh. The sawmill owners' names are given who's just set up in Dibrugarh. This is somewhere in the Dibrugarh, that Ramari idea.
Or Dibru Saikia. Okay.
Their case, as per the appears from the body report, it is the one Puram. We had said that we are with them.
What is the name of the petitioner?
One is Pinku, another is Dhanti Das.
Pinku Das and Dhanti Das. And the second application is?
It's only one.
Huh?
Those who are called for consideration along with this application, those are
Oh,
disposed.
acha.
Those are disposed of. The bail application 3159 of 2023 that was filed by the Cochran that has been rejected. And the CD reveals there what it appears from the said order.
But witnesses have implicated you. You are doing business for a long time. And the statements I am not naming the witnesses. They say that the timbers were being collected through river by making raft from Arunachal Pradesh and other neighboring areas. Those logs were cut at different locations and transported to different locations. You also say that you were doing timber business openly without any fear even in the daytime. And forest officials used to visit your sawmills. They've been identifying those forest staff.
From the forwarding report, what it appears, it is because of the allegation put forth by the this arrested accused, Deepak Guram. And his rejection order will find. He said the owner of the sawmill is one Subroto Gogoi. as revealed from the order that, by which the program bail application was rejected. On the statement of this particular witness,
No, there are allegations against you,
by the program.
specifically named by witnesses and no, Mr. Fesage, we'll have to reject it. There are materials here.
21 days for the custody.
No, but still, no. There are allegations that timber is also being smuggled from Dibru Saikwa National Park. Specific,
So these allegations are omnibus allegations against the.
no, you see, it can't be tracked out. We don't have a tracking device for this forest produce. It may be from taken from Guwahati also, we don't know. It maybe from a different area, we don't know. Maybe from a private forest, we don't know. But that is how the case is built up against you.
These are implicated directly against that, my instruction. And also what is appears from this order of the program. The owner of that particular.
No, Mr. Saiga, there are a lot of materials. 65 timber logs were found in this operation.
These were recovered from the Dipakura.
No, wherever be, I'm not on the specifics, but in this operation, 5 sawmills were found, and out of other things, 65 timber logs. No. But right now, forest officers are arrested. When the BIO is finding evidence of forest officials being there, you're leaving them out. Has been arrested, forest official.
The investigation is pending.
Hmm?
Investigation is pending.
Heard Mr. PJ Saiga, Senior Counsel, assisted by Ms. Amnirullah, Counsel for the petitioners, and Mr. RJ Barbat and APP for the state. Next paragraph. The petitioners were arrested on 28/9/2023 in connection with the IEO case, page 1. So is I have prayed for regular bail under section 439 CRPC. It is projected by the projected in this application that the petitioner number one is a petty businessman having a small grocery shop with a trade license, and that the petitioner number two is a cultivator, and that they have been falsely implicated in the alleged offense for which FIR was filed on 25/8/2023. First, on a perusal of the case diary produced by the London APP, it appears that there are materials against the petitioners are being involved in the illegal trade of dealing in forest produce like timber. The evidence collected so far indicates that the petitioners are involved in such illegal trade of timber. There are materials to show that the operators in this business, illegal business, obtain logs from parts of Dibru Saikwa, what is it called? Dibru Saikwa National Park, as well as from Arunachal Pradesh. Next, accordingly, in view of the investigation that is, in the interest of investigation that is under progress, court does not find this to be a fit case to release the petitioners on bail at this stage. Case diary written, application disposed of.
Item 16.
Yes.
We are behind the class for the last 19 days.
419,387. Where is your FIR?
Page 13. Allegation is that we try to extort money from me. May I?
Page 13.
30. May I? Most importantly, I beg to state that I, along with Mintu Rahman, is running a biscuit bakery factory at Jayanagar near petrol pump for the last 8 months. It is not only to mention that today that we got 29/9 around 1 o'clock a group of 6 Mexicans came and introduced themselves to the inspectors and demanded an amount of ₹3 lakhs from me, and I tried to commit the authority during the day. Moreover, a fake journalist who was also booked by them. They are threatening me if I did not pay them.
What is there in the case diary? Not received. You are arrested when?
19th year also. Well, so sorry, on 29th, the same day, but we were forwarded on 30th year also. And may I submit a lordship, from the very day that we have been arrested, we are behind bail. We have not been taken to any further investigation. Hearing came from 29th, 30th. In my submission, your lordship, the further participants may not be necessary. And one more aspect, your lordship, may kindly peruse page 17.
Yes.
This is certified that the following persons, namely the petitioner's active petitioners. are the workers and members of Dasit Sena or from Kolgil. So what we had heard on that particular day, Your Lordship, that particular break.
No, after that name, you don't have to explain, we know what, what is happening.
On
What
that
is happening, we know
particular
that.
day- On that particular day, we received an information that on that particular bakery, Your Lordship, young boys are being employed, minors are being employed. This is why we went to inquire for that. In fact,
No, that authority you don't have.
true.
That you don't have.
Unfortunately, Your Lordship, this case was filed. The
You see,
extortion part-
you see, unfortunately, I come from a community where we have to deal with these people. Not once. And people who know me will tell you that I have a lot of experience in dealing with these people.
But I'd like to take some people, necessary. Now, the 20 days already.
I have to get a Kilzari. How many accused are there? But for these people, custodial interrogation will not be required. Case of extortion. You call yourself members of Sena. Sena means army. Army means disciplined. Correct. Now you tell us what social service you will do in this puja if you are released.
And Your Lordship, Your Lordship, I will definitely do some sort of-
Which place you live?
We are all.
No. You personally, where do you live?
So I stay in Narangi.
In Narangi. In Narangi, there is any puja committee? They'll render their service 8 hours a day.
Yes. They will.
Being a person of what you call members of uniformed people, it will be a condition of bail.
Definitely. I'll ensure that they.
Do volunteer service.
Yes.
Correct. Control the crowd in the evening in the puja, local puja committee, and get a report to the IO of having rendered service from that Durga Puja committee.
Yes.
Correct.
Yes.
Heard Mr. T. Deori, counsel for the petitioners, and Mr. R.J. Barwal, and the APP for the state. Petitioners were arrested on 30/9/2023 in connection with this PS case number 1911 of 2023 under section so and so, page 1. Paid for regular bail under section 439 CRPC. The learned APP has prayed for some more time to produce the case diary, which has not been received. And he also opposes the prayer for bail without perusal of the case diary. Next para. It appears from the FIR that the petitioners had masqueraded masquerade, spelling would be masqueraded as food inspectors and demanded rupees 3 lakh from a particular bakery. And on the police being informed, out of 6 people, 4 were arrested. Out of six such miscreants, the 4 petitioners were arrested on spot. Full stop. The petitioners claim to be members of Lachit Sena. Next para. Having regard to the nature of offense. Just add one more thing. And on refusal of the said bakery to pay the demand of extortion, the persons of that bakery was assaulted, physically assaulted. Yes. Having regard to the nature of offense and the ensuing Durga Puja, the court is inclined to grant interim bail to the petitioners till 6/11/2023 by providing that condition for grant of bail that during this Puja festivities from Saptami to Dashami, all the petitioners shall render voluntary service in a Durga Puja committee in Narangi area and obtain a certificate of having rendered voluntary public service. Shall provide that certificate to the IO. Full stop. As a condition for grant, the interim bail is granted on the following conditions. The other conditions that they will appear before the IO within 7 days. Next paragraph. The extension of bail for thereafter shall be considered only on receipt of the case diary. Yes, list so on so and so for case diary 6 or 7th. 7th, 7th. 11th, 9th, okay, 9/11 case diary. Unusual order.
I'm deeply obliged, Your Lord.
Bill bond is 30,000 each. Okay.
Item 17.
Today, since members of the bar are not there, you won't be able to gossip. So therefore, therefore this order. And maybe when you look at Ma Durga, maybe when these people will look at Ma Durga, they will know only to fight evil, not good people. Correct. And I'll tell you something. That is my personal feeling. You see, please assume a state where there is no businessman. Assume there is a state where there is no businessman. Will the society survive without a businessman? So therefore, government will not be able to give everybody a job. So these people who are in business, whoever it may be, irrespective of caste, religion, community, they are one of the pillars of the society. They are generating their income for their own. And there is a very bad perception here, especially this Lachit Sena. It's not one incident. Their vandalizing incidents are plenty, not one. In the state of, in this Guwahati city, there are plenty of examples where they have vandalized business shops. They had been, they had assaulted staff and the business establishment of Vishal. Correct?
Yes.
So that's why I'm saying this community service was given only for that reason, number one. Number two, so whoever is that businessman, he's not taking something from the society, he's giving a service.
Yes.
Correct.
Yes.
So therefore, unless you permit people to live freely, nobody is going to come and invest in the state. Therefore, this investment in the state is becoming a failure. It's not happening. And everybody thinks there's a bad habit of thinking that, okay, this shop has so much of items, this much of sales, so everything is profit. They think everything, every penny sold, every rupee sold by the shop is the 100% profit. That's why these people must know that if you fight with your own people, it will not be a good state.
The case that has not come up, my submission will be recorded.
No, I have recorded it. A submission is recorded. I have written your objection.
I'm of that.
And then I have also, that's why I have given an interim bail for production of case diary. That's why this condition, otherwise I would not have given that condition. Maybe perhaps when they do that service, they will understand. Yes, item 17.
16 days behind the border. 16 days behind the border.
16 days, what did you do? 379.
Not in the FIR number. You work in a.
Oh, nobody gives for committing an offense of 379. You don't carry a visiting card, give it to the persons. That now I am committing this crime. Will you please, this is my business card. Correct.
Working in a secret material depot location and FIR page number. Well,
He's the parcels are stolen. That's all.
The purchaser of stolen goods.
It is even from the case diary.
it's only a worker.
No, then we not give it to you. You have to be there for some days.
Who was it from Pakistan? Two other person was there.
What is the base band?
So that is, there are some other towers for the mobile tower, that is located not only there for the house.
Yes.
From there, also they've stolen the, so like, I am also not clear, also, but the bottom like battery.
No, then we are not giving you bail.
It's expensive. It's expensive.
Those are not from the two other person.
It's two other person, it was recovered, but it was not, they have started that it was sold to this accused person.
The accused person is.
No, no, these are costly equipments. Mr. S. Neo, counsel for the petitioners, only one petitioner. And Mr. Haji Barur and APP for the state. The petitioner was arrested in connection with Sonapur PS case number 208, page 1. The split was arrested on 27/9/2023. No, sorry. On 3/10/2023. Paid for regular bail under 439 CRPC. The learned counsel for the petitioner has submitted that he is not the FIR named accused and the items which were recovered were not from his premises. Next paragraph. On a perusal of the case diary, it appears that the allegation that the investigation carried out so far. Hence, to the petitioner being habitual purchaser of stolen equipments, sorry, equipments. And there are materials to, in the case, right, to implicate the petitioner of being a purchaser of the stolen equipments. First of all, this is circumstance, in the interest of investigation, the prayer for bail is refused. Let the case diary be sent back.
No, the fiscal section was there, report hacking was not there, only 17 minutes.
Still. Item 18.
Come after question also.
After,
After vacation also, because no recovery was there, also on a suspicion, also is FC 17 and running to a chapter 2 motorcycle also. Though they were on suspicion, they were arrested also. I think what you updated that recovery is not there.
okay, you have changed your name from Samrat to Smart. No, but we'll accommodate you. Just after ensuing vacation is 7, 11, additional 7, 11, 8, 11.
Stand back lordship, the 10, 11.
Oh, okay, I'll,
10 for after
I'll-
city. But
that's what I'm saying. I'll put it in your mouth instead of Mr. Smart. Both says the represented. Ms. A. Begum Learned APP submitted that the case diary is received, which is not updated. Just accordingly, that the case diary is sent back for updation. List on 9. You want 9th?
Actually, I wanted on 8.
8, okay, yes, 8, 11, 2023.
not up to date lordship, we have received the CD lordship as he is submitting lordship. Otherwise, we have received the CD lordship.
Yes,
So that
You
the
you know what is happening.
No. what is the
You know what is happening. Correct.
Much of like this, much of.
At times we have to accommodate.
lordship?
Happy Puja.
It's only an accommodation to Mr. I have changed his name, Smart. Mr. Smart.
Happy Puja.
Happy Puja.
Item 19.
Yes,
Lordship, we have not received CD lordship in this case lordship.
That is at 10:14.
1610, we have sent our message lordship, so CD will be required. lordship. As
just a moment. What is the FIR? Let us see the FIR.
Page 14. In this case, both the name person in the FIR has been granted bail. I am not the name person. in this. It is granted, the main accused has been granted indisputed bail, AP. I'm nowhere connected you guys. I'm only a driver.
No, you are the named accused.
I am not the name. My name is Sokat Ali.
SAUKAT.
Yes, sir.
Your name is number 1 in the forwarding.
Forwarding, I was arrested. You know. The main accused, your lordship, the Rahul Ali, with whom this, the, process regarding Udup, your lordship.
No,
He
no,
is
but
granted-
once a case of kidnapping of a girl,
But you know, the main person, already, he's already on bail, on anticipated bail of AB. And another person, you also Saiful Islam. In his pushing, the person out there, you also, he also granted bail, you know. On the
that may be
basis of-
the, you see, that may be the wisdom of the court, but when a girl is missing, if I release the accused person
That is recovered, your. That is recovered,
recovered,
your lordship, after 9 months.
But we will not receive, lordship.
we don't know.
We don't know about that.
Annexure 3, your lordship.
Annexure, page.
Video call. Sir, pen drive, has been granted, because since he has to give it a statement-
Pen drive, we won't have time to look at pen drive.
Yes, sir.
Then,
But your lordship, my one submission, your lordship. Both the prime accused have been granted bail.
no, that may be, but see, the girl has to be recovered. That is the first and foremost. Have you made a statement in your application? The girl has been recovered.
Para 11 euros. That's 6.
Then we'll release him on that basis. We are giving an interim bail then.
Lordship, he is behind the bar. lordship.
I'm behind the bar.
He is behind the
No,
bar.
no, it's okay. Still we can grant an interim bail. We'll have an undertaking by him to surrender on receipt of case diary. Heard Mr. Anand Jha, counsel for the appellate, petitioner, and Miss A. Begum, runner APP for the state. Application 439. Chancery PS, page 1. They done it. APP prays for some more time to obtain the case diary. Next, the learned counsel for the petitioner submitted that the petition is not the FIR named accused. And it is, and by referring to statement made in paragraph 11 of this application, it is submitted that the victim girl was not kidnapped, but she had eloped. On having relationship with the named accused, FIR named accused. So it is submitted that the video statement of the victim girl before the media is has been produced before this court in a pen drive as an Annexure 3. Just accordingly, it is submitted that the victim girl has been recovered and she has also addressed the media. Stop considering the same. Come on. Awaiting receipt of the case diary. The court is inclined to grant interim bail to the petitioner, namely so and so, providing that in the event he furnishes a bail bond before the court of learned, bail bond of rupees 30,000 with one surety to the satisfaction of the learned chief judicial magistrate. This is which place? Kamrup, Aminggaon. the petitioner shall be released on a temporary bail for a period of to 8/11/2023. First of the release of the petitioner would be subject to condition that along with the bail bond, the petitioner shall submit undertaking to surrender before the said learned court. In the event this application for bail is decided against him on result of the case diary. Post on next paragraph. In order to facilitate the petitioner to submit such bond, it is also provided that the family members of the petitioner is permitted to visit the jail where he has been presently lodged to have the signature taken on the undertaking through the jailer, public superintendent of jail. Interim bail is granted on the following conditions. Shall appear before the eye within 7 days. Next paragraph. Further extension of bail would be subject to further orders that may be passed on the next date. List on so and so for case diary. Yes. 9/11. Okay. 20.
Item 20.
What you mean, 20 also, Lordship, we have not received the case diary, Lordship.
Okay, petition is not there. Okay, list from the list after vacation. Give a date after vacation. There is bill matter for production of case diary.
It was 10/11.
10. Okay. Case diary, scan copy thereof. Okay, 39.
Item 39.
You have the case diary?
Lordship, I have.
Who are you?
But that documents are not submitted in the to IR.
Shows that.
There is no
No, it's
document.
okay. Let me see the case diary. But Mr. Begum, in this case, there's nothing, nothing reflected about the present petitioner.
Lordship. Only two witnesses are examined, Lordship, and three witnesses doesn't reveal his name, Lordship.
It doesn't reveal.
Only
granted
the
bail.
objection of the, there is that, he should not be granted, only that much.
Will be entitled to bail. In this case diary. Because prior to this, the investigation was better. In this case, I am not finding because I am taking a bail after a long time,
Lordship, Lordship,
after about 3-4 months.
Lordship.
But this quality of investigation has deteriorated. Here they have not given the description of the vehicle where it was taken. What is the class of vehicle? What is the, those things are not there. Heard Mr. T. Sudhir, learned counsel for the petitioner. And Ms. A. Begum, learned APP for the state. Next. Apprehending arrest in connection with Morrigaon PS case numbers, so and so, pays bail under 438 CRPC. Next. The petitioner is accused. The Honorable APP has produced the case diary and has opposed the prayer for bail on the ground that the investigation is at the nascent stage and that how many cows? 24 cows. 24 bull. 24. What is the figure?
24
Okay, and 24 bulls
goods.
were found being transported in a truck in a cruel manner. So it is also submitted that it is apprehended that this all the cattle which have been seized are all stolen cattle. Next paragraph, on a perusal of the case diary, it does not appear that that it contains incumbent materials sufficient to deny PRS bail to the petitioner. First of, in this application, the petitioner has produced copy of purchase vouchers of cattle from the cattle market. As an extra 5 series. From the Bali Satra, BALI-SATRA, Satra, half dash weekly market under Nagaon Zilla Parishad. First off, in such circumstances, court is inclined to grant PRS bail to the petitioner, namely so and so, and providing that in the event of his arrest, rupees 30,000 with one surety of like amount to the satisfaction of the arresting officer. Other conditions say that the petitioner shall appear before the IO within 10 days from today, failing which the protection of the petitioner would lapse, stand lapsed on the 11th day. Case diary written, application disposed of.
Time being was 8.
Okay, item 8.
Because it's board number 20.
Okay. Okay. Any material there against?
Both such material, because my road, as part of my road, the 41 notice was subsequent. And pursuant to that notice, he appeared before the IO. Now, why he has filed his application with that? Why he has prepared his application with that? I don't know.
No material.
100% more such implicating material. Then he has prepared his application. His apprehension has to be genuine and reasonable.
Huh?
His apprehension has to be genuine and reasonable.
So we'll close it by saying that since there is no material against him,
I know he has already appeared pursuant to the 41 and 52.
Huh?
41
out of
and
41 he has appeared.
pursuant to that he has
Okay.
appeared.
None appears on call for the petitioner. However, Mr. R.J. Barwal and APP is present. The apprehending arrest in connection with case 2, here is bill under 438, next para. The learned APP has produced the case diary and has submitted that pursuant to notice issued under section 41 capital A CRPC, the petitioner has already appeared before the IO. And there is no direction for him to further appear. Mr. Under such circumstances, the court finds that the apprehension of the petitioner being arrested is without any basis, and according to this, as the petitioner is no longer wanted in the said case, as on date, this application stands closed.
That is not clearly taken from the case.
It's okay, we are saying that as on date, you are not having closed. Yes, item 12. Yes, Mr. Acharya. On? Only on quantum. Okay, deposit 50%.
50% with interest loss. 50% with interest loss.
Interest will calculate, we'll keep it open. We'll issue the direction. After this, they give the principal. They'll give it within 6 weeks' time. On that day, you renew the prayer. We're keeping it open. We are not closing that.
My prayer is that they offered the awarded amount. The claimant is not agree. They offered the awarded amount. Settle the matter at the awarded amount.
No, now they have challenged it.
They have challenged it, but after filing of the case, appeal, they offered the settled amount without interest.
No, that we don't know. Now they are depositing 50%. We are keeping it open. We'll consider it on the reopening day. You renew the prayer on that day for interest. Correct?
Yes.
We are not granting it today. Mr. A. Acharya, counsel for the appellant, and Mr. M. Talukdar, counsel for the respondent number 1. Appeal number 173 against the judgment and award of so. Appeal is admitted for hearing, call for the records. Appellant shall take steps. He has appeared. Okay. As the respondent who has entered appearance in connection with the connected interlocutory application for condemnation of delay. The learned counsel for the appellant shall serve a copy of the memo appeal with enclosures to the learned counsel for the, you have also received to the counsel for respondent number 2. Let the LCR be called for. And in the IU, you say, stay subject to deposit of 50% of the awarded sum as the registry of the court within a period of 6 weeks from today. How much is the amount?
38,67,000.
Okay, I will simply stop. The learned counsel for the respondent number 1 is permitted to renew the prayer for payment of interest on the next date of listing. Next para. It is provided that on the 50% of award being deposited before the registry of the court, the registry shall permit the respondent number 1, opposite party number 1 to withdraw the amount on being satisfied with regard the identity of the respondent number 1. So in the meanwhile, the counsel for the respondent number 1 shall provide the bank details and particulars to the learned counsel for the applicant. as well as to the registry for transfer of the funds to the for online transfer of funds to the opposite party number 1. List after 6 weeks.
Putting the money in registry or the direct account?
No, whatever whatever you do, at the registry also I am permitting. Either to him directly or through the registry.
Maybe that deposited from the registry. Registry.
Give it to the registry. Okay. But nonetheless, you provide that, we will be incorporating because there is a Delhi High Court judgment which has been approved by the accepted by the Supreme Court in principle, where they are wanting to weed out middlemen. So therefore, if payment is to be made, the amount can be directly transferred so that there is no middleman to take out that money. No, that is okay, but whenever some deposits are made, the Delhi High Court has taken a view, because you see, it's not only in one case. There are multiplied n numbers of cases where the actual awarded amount has not gone to the victim. There are middlemen who siphon off their money. So therefore, we are providing this, at least when I am ordering now, when I remember, I may not remember every time, but when I remember, I issue the direction to provide the bank details so that middlemen are ousted. That's the only reason. It sounds uncomfortable, but that is the reality. No, I'm not accusing you of anything. Don't take it personally, but this is what is general perception. I'm not accusing you particularly. I'm not pinpointing you, but I'm saying that this is the view expressed by the Delhi High Court. And this is in principle accepted by the Supreme Court. There are several guidelines of Delhi High Court, which has been gradually being accepted by the Supreme Court. For example, the spread out of money on what you call small FDs and all, everything. We are not doing in Guwahati, but I think we'll also have to take a decision and implement the same thing. Money broken up in fixed deposits, given it to the applicants. This only to safeguard their money, nothing else. Yes, item 24.
With production list item 1.
Mr. Sheikh, your matter.
Here in this case, my lord, there is a second history. What happened, my lord? I filed an appeal under section 100. So, my lord, registry registered the same.
No, this is a review application.
My lord, new application. No, my lord, I am giving the background.
Huh.
So what happened, my lord? It was registered at SO. Second appeal from order. However, my lord, your lordship admitted that appeal. And interim order was stayed. And there was an IA, my lord. IA was also interim order was passed. Execution was stayed. Subsequently, my lord, it came before your lordship. Then your lordship detected that, oh no, it cannot be registered as SAO. So your lordship directed the appellant to withdraw the case and file it properly. And learned counsel could not point out this, that actually I have filed a second appeal, proper second appeal, RS. So my lord, case was withdrawn. Thereafter, my lord, after examination, I found that no, it was a proper RS. Then I filed a review against that withdrawal order. And your lordship was pleased to recall that order closing the SAO and directed the registry to register the case as regular second appeal. Now this second appeal is withdrawn.
Okay.
My lord, I am appearing on as a debater. My lord, the document number 3 is 25. It appears to be not visible. Page 25, my lord, document number 3. First page is basically, my lord, not clear. Document number 2, page 25.
If lordship, copy is clear, I have nothing to say, but my copy very difficult to.
Oh, no, because I read only a small part of whatever is there and from my opinion. I don't read the entire order. So, order 21 rule 97. So what has happened? You are third party. Mr. Sheikh, you are a third party. You are a third party.
Yes.
You are the decree holder or a third party?
I'm 30%.
You are third party.
Not made party in the original suit, my lord. A suit was brought up to High Court. Thereafter, I filed the miscase. This is a case 65 of 2012.
What is the date of your filing? The title suit is of 2003.
Title suit,
Is of 2003.
yes, ma'am. My lord, I filed it in 2012, my lord. Filed
Decree
it
was passed when?
first-
This suit was decreed when?
First decree, my lord.
Yes, that the suit of 512 of 2003,
My lord.
which is subsequently numbers as 112 of 2007. This was decreed when?
My lord, I'm thinking.
Or the suit was dismissed.
Yes. Suit was dismissed first, madam. Thereafter, appeal was preferred. Your lordship will turn to page 14, my lord. Para 5. Native. Suit was dismissed and the plaintiff of the said suit filed title appeal number 25 of 2009 in the Court of Civil Justice. And that was allowed. And thereafter, my lord, RSA was filed before the honorable.
Just a moment, just a moment. Title 25 of 2009. Okay,
It was of 2000
this appeal was allowed.
RSA. Yes, appeal was allowed.
Appeal was allowed.
Thereafter, the defendant came before the honorable High Court by RSA. Filing RSA.
Appeal was allowed. You have the date of the title appeal?
The title appeal was dismissed, my lord.
Title appeal was.
Title appeal 25. of
Appeal was
2000.
allowed and the suit was decreed.
And thereafter, my lord, RSA. In
No,
2011.
you have the
which was
dates.
dismissed on 1/11/2000. Last word. Paragraph. 2011 it was.
Appeal allowed. Then RSA came.
And the RSA.
RSA is 277 of 2011.
Yes.
Yes.
But your lordship.
Then
asked
you
me
file
regarding filing,
after this litigation.
It was August
No,
2012.
just a moment. After this litigation ended in RSA, you did not file a second appeal before the Supreme Court. No, you file a suit again.
It is a final.
You file a suit again.
No, not the party against whom RSA was decided. They are third party.
No. Who has filed TS 21 of 2012?
TS of 2012, it is not TS, my lord, it is a military case.
No. You filed TS. Perhaps you have filed the TS.
No, my lord,
This Mijay 65 is by whom?
65 by the petitioner.
No. Then you please prepare the brief. We'll take it up some other day after vacation. Come to page 26. I told you I read
Yes, ma'am.
parts of it.
Paragraph
I
five.
don't read the entire.
Paragraph
Document.
five, 26.
Come to page 26. Para 5, you will find that, sorry, just before para 5. No, not that. In para 5, sorry, after 6 lines.
Yes.
The TS number, the petitioners filed TS bearing 21 or 2012, paying for declaration of the right title and interest. We'll take it up after vacation, Mr. Sheikh, because after 5 minutes, none of my orders would be uploaded. Correct. We'll take it up after vacation. Please be prepared. Due to positive time, matter could not be taken up today. Mr. M. A. Sheikh, counsel for the appellant, and Mr. A.R. Sridhar, counsel for the respondent, caveator, is present.
But only one thing, madam. Actually, my appeal was withdrawn, then is restored to 5 lakhs. And in this case, my lord, in this case, the appeal is already admitted by the coordinate bench. So the interim order was stayed. Now, my lord, what happened? While the appeal was restored to file, my lord, it should be this IA also restored to file. my lord. But nothing has been mentioned in that order.
No, in this second appellate order, I don't find that any substantial question of law was framed.
Not substantial question of law was not framed.
So that not,
That is one thing, my lord. That your coordinate bench, your lordship,
That appeal was also not managed.
coordinate bench, consider the substantial question I have formulated in 11 in number. So appeal was admitted.
no,
Now
it was
what
not admitted. It was not admitted.
My lord, appeal was admitted, that order I am. Your lordship would be pleased to take the review petition. Review petition at page 87. Review petition number 119 of 2020.
Page 87.
Page 87. Your lordship would be pleased to see, in the appeal memo, the appellant has framed 11 substantial question of law.
Oh, that is not admission. Please don't argue that before us, this court.
My lord, that is all right, my lord.
Yeah.
What I am on, my lord, definitely your lordship will formulate the substantial question of law. But the honorable coordinator.
No, Mr. Sheikh, you see, I'm giving you time, but you're not prepared. When I'm asking question, you are not prepared. I can't devote so much of time because the sections will close.
The thing is this, my lord, I have my residential houses. Now my residential houses for about 50 years, my lord, on the shoe plan. So my lord, my humble submission before your lordship.
You see,
as the
till
appeal is admitted, otherwise, my lord, if protection. is not
Mr.
given,
Sheikh,
I
you
will
see-
in problem, my lord.
no, you will not be in problem because till the civil courts are closed till 30. You have not shown anything that execution writ has been issued against you for demolition of the houses.
My lord, that is there, my, that is there. Because,
Mr.
my lord,
Sheikh,
case,
Mr. Sheikh,
execution case is started. No, my
Mr.
lord,
Sheikh,
what is the ground
please
for the-
understand, I was there where you are standing for 25 years. Where you are standing, I was there for 25 years. Therefore, I am aware when execution will take place. Please tell us if you can show us that a writ has been issued. We'll pass orders.
My humble submission before your lordship.
Mr. Sheikh, you can take hours and hours. Let me finish few matters in few moments. You wait for some time, we'll dispose of other matters and I'll take up your matter again. Because if I don't pass or sign orders, it will not be uploaded. Please understand that. I have an urgency. Today is the last working day. If I don't sign these orders, it will not be uploaded.
Only one sentence I am placing.
No, unless these substantial questions are framed, I am not going to pass any order.
No, but a substantial question is framed by the, substantial question is not framed by coordinate bench admitted the appeal, my lord.
We'll take care of that.
Admitted the appeal, my lord, it will not
Mr. Sheikh,
state.
Mr. Sheikh, I know how to pass orders. I'll do it. Don't worry about that. But this substantial question is not framed. And if you insist, we are also prepared to pass appropriate orders. Please wait for some time. Let me finish other matters and let others go. I'll take up your matter again. Just wait for some time.
Let it come after that.
We'll take it up after some time. Don't go disheartened from the court that I have not been heard.
Okay, my lord, it may be taken
Huh.
after vacation number 6.
I don't want anybody to go disheartened that I have not heard them.
6/11.
Correct.
No, my lord, it
Huh.
is now 4:50.
Huh.
So, my lord, it may be listed on 6/11.
No, not 6th, 7th. 6th, it will not come because it will not go to this section. And 7, the one list one, so and so.
7.
Huh.
Item 25 with 26.
Item number 30, because on 8th, there is a day for execution. It will come on 7th. Item 30.
Item 30, just wait for some time.
But I have to put it.
Oh, acha, okay. 7/11. Oh, okay, on the, Mr. P.K. Roy Chaudhary, counsel for the appellant is present. Due to positive time matter could not be taken up today. List on 7/11/2023. Item 25/26.
40 seconds were placed before the conciliator on 11/10. There was no compromise. Let the matter come regularly.
Okay, it will go for hearing.
As
Okay.
usual.
Okay, it's
IAS regarding the IA also pending, my lord.
IA for,
IA for my lord, for restraining and prohibiting the opposite party to their. We have given our objections, let the matter be heard for IA.
you filed your objection
Next, already filed. After vacation. my lord.
after vacation. We'll give a date. Both sides are represented by the respective land council. So it has been submitted to the bar that in the conciliation mediation process, the settlement could not take place. Full stop. Next, it appears that there is an interlocutory application pending. So due to positive time matter could not be taken up today. List on 10/11/2023.
All right. Item 27.
Yes,
That time, the respondent number 125.
why it has come today?
Service is still awaiting for respondent number 6.
7. None appears for call on the, on call for the appellant. However, Mr. V. Kumar, counsel for the respondent is present. There's only one respondent or more?
125.
Or all the respondents is present.
Respondent 125. 6 is service is still awaiting for 6.
Oh, acha, respondent numbers 1 to 5 is present. First of all, he has submitted that submitted by referring to office note dated 16/10/2023 that steps had not been taken for service of notice on for respondent number 6. So it is also submitted that no, first of all, it is seen from the said office note that as per the postal endorsement, the address of performer respondent number 6 is incomplete. Next, but accordingly, the learned counsel for the applicant, sorry, appellant, shall provide the correct postal address of the respondent numbers, performer respondent number 6. Full stop. List after ensuing vacation. You are the plaintiff for the defendant? You are the defendants. The suit was dismissed. Okay. List after vacation. Okay. 28. Yes, it's good to see you after so long time. It is good to see you after a long time. Yes,
You know, the appeal was dismissed for default in the year 2012, my lord.
okay,
Because unfortunately, Granite Senior Council had left this world in the meanwhile.
okay.
His junior also died subsequently.
Oh,
So
oh.
there was no representation, my lord. And when.
No, but service is not yet complete.
My lord, it was not contested.
No, here also service is not complete in this IA.
Yes. 6, 7 IAs are there. My lord, why? Because now today it is 3407 of 2019.
Yes,
That is under section 5 of the limitation.
under 5 of the Limitation Act, here service is not complete.
For substitution of the.
No, no, here service is not complete.
No, my lord, Lozama has reported and this honorable court was pleased to hold that service is complete, my lord. I have noted here, it is very clear, my lord. On 12/6/19, honorable court passed an order as per office note dated 25/1/2019. As
619.
12/6/19, my lord. There's an order. As per-
No,
uh,
you see here in this application,
uh,
first order was issued on 22/11/2019.
Oh, that was actually in IHC 148. 148 is for delay condonation in restoration of the appeal, my lord. Oh, no, my lord, I'm sorry. Delay condonation for appeal is 1840. 1842 is the readmission. And 3148 is for substitution, my lord. What had happened in 3148 of 18, notice was issued. Then the learned counsel prayed for time to file a petition for condonation.
Acha, okay, just this order in 1840, you said that the service is complete.
Yes, 3407 of 2019. Here your lordship may be pleased to look into the order 28/6/20, 2020.
In which 3407
3407,
order dated
28/6/2022.
28/6/22.
Office note, my lord, office note.
No, I've seen that. It says that postal endorsement number 1 expired, number 2 to 3, 2 to 6 refused.
Yes. One respondent's process server report, respond number 1 expired, 2 to 6 notices served by hanging on the wall of the dwelling house of the respondents. As regards registered post, answered notices have been received from respond number 1 to 6, and the same has been placed on record, shown as flag white. Respondents postal endorsement, respond number 1 expired, respond number 2 to 6 refused, my lord.
Oh, acha.
So service is complete.
Okay, 3407, heard Ms. B. Chaudhary, counsel for the applicants. As per office note dated 28/6/2022, comma, respondent number 1 has expired and the respondent numbers 2 to 6 have refused service as per postal endorsement and as per the process service report. Comma, notice on respondent numbers 2 to 6 was hanged on the wall of the dwelling house of the respondents. So accordingly, notice on, we said, on the respondent numbers 2 to 6 are deemed to be duly served. None appears on call for the said respondents. Now, which is the application for substitution?
That is 3148 of 2008.
3148.
Yes, I have 3148 of 2008. There's a report of Lozama also.
No, there is a
court's order also is there, my
No,
lord.
there is a delay also in this.
My lord.
There was a delay in application, filing application.
Yes, yes, my delay. My lord, today my prayer will be, although to my former lawyer, my lord, due to inadvertence,
No, it's okay.
petition was filed for condonation, petition was filed for substitution. But there is no petition for setting aside abatement, my lord. So I may be allowed, because I have made it ready,
Okay.
I may be allowed to
Okay,
file it, but the office is not accepting. Because registry refused that this is a closed matter, it will dismiss for default. So.
Okay,
lordship
okay.
wishes to pass an order.
This order will be passed in 3148. In three,
3148, yes, my lord, that is for substitution of 2018.
okay. 3148, you're right, Ms. B. Chaudhary, learned counsel for the applicant, has submitted that unfortunately in this case, the counsel holding the brief as well as his instructing counsel had both expired. And on a perusal of the record, she finds that although application for substitution and condonation of delay were filed in substituting the deceased respondent number 1, but application for setting as abetment, she did not find on record. Accordingly, on her prayer, she is permitted to file the appropriate application in that regard. Full stop. Matter stands deferred today, list after vacation. Okay,
No, bless my lord.
okay. Yes. Yes, Mr. Sheikh.
My lord, Oxford Cable matter 12/10/2023. This upon respondent number 1, the Roman 124 matter is completed. And my lord, regarding respondent number 5 and 6,
5 and 6.
my lord, not completed, and just not found, my lord.
You certainly collect this, will list after vacation.
They might not do- because they are the legal here, my lord. Two sisters, my lord, they have married to another. My lord, they must know the.
Try to find out. If you have the
they are the
particulars of the
brothers.
sister, give it to him.
Yes. They are the
Okay.
brothers, my lord, and sisters.
It's
they
okay.
are already married.
No, married is something else, but if you have the address, you can share it. Otherwise, you see, notice can otherwise be served by newspaper publication. Substitute service can be made, but it will make expenditure unnecessarily. Heard. Mr. T. Sheikh, counsel for the applicant, and Mr. P. D. Bhuya, learned counsel for the opposite parties. Number
As per 1, 327.
1 and 3 to 7.
Okay. Expert number 3 is expired on 27/9/2023.
Okay. Next, it is submitted by the learned counsel for the appearing respondents, opposite parties, that the respondent number 3 namely Mohammed MD Darejuddin, Parejuddin Ahmed alias Diraj, Derej Ali, has expired on
27/9/2023.
27/9/2023. Post from. Next. No, not that we continue. Accordingly, the learned counsel for the applicant shall take notice of the said submission and take appropriate steps. Next para. The learned counsel for the applicant has submitted that as per the office note dated 12/10/2023, the respondent numbers, opposite party numbers 2 within bracket Roman 5 and 2 within bracket Roman 6 were not found So it is submitted that the said substituted opposite parties are the family members of the other opposite parties. So accordingly, the learned counsel for the appearing opposite parties shall ascertain the shall take instructions with the correct address of the said respondents and share it with the learned counsel for the applicant. Next para. List after ensuing vacation. If he can't collect for some reason, then you have to make paper publication. Substituted service you'll have to make. Okay.